May I have your lordship kind leave, my lord.
Ah.
Drawing up of your lordship
Huh?
past drawing up of your lordship's two orders, my lord, passed in the same group. Lord, one is on 7th April and one is on 29th April.
My lord, may I be permitted to mention one matter, my lord? My lord, if my lord recollects the Mr. Dev is leading me in this matter, we have filed an application under Section 7 of the Charitable and Religious Trust Act, and by an order and judgment dated 11 December 2024, we have been permitted to sell the property. Now the matter is pending only for filing of the compliance report.
But that is not with the jurisdiction.
No, it is a part-head matter, and it
No,
was
it is not
appearing.
parted. Parted.
It was appearing in the.
It was appearing. I know, but
on Friday it was
Parted.
appearing, being item number 31.
okay,
If
it will be listed.
some preference only for filing of the report, and presently I am also carrying the report
Report
filed by the petitioners
for what?
that we have sold the property, we have opened a joint account, and the amount have been deposited to the
Which property it is? Which property?
my
Mr. Deva. Yes, yes. अब रखिएगा फ्राइडे तो छुट्टी है फ्राइडे छुट्टी है ना
grateful.
May I permitted to mention a matter, Lordship? My matter is for the correction of the order sheet, Lordship. On 28th of April 2025, Lordship pleased to pass an order wherein Lordship pleased to record that defendant number 10 not filed their written objection. Lordship, we have filed our written objection on the department, Lordship. Lordship, in item number, serial number 18, Lordship, you will find, Lordship, we have filed our written objection within a period granted by your Lordship. Serial number 19, Lordship.
When you filed?
We have filed on 13th of March 2025, Lordship.
Who? You filed?
Yes, Lordship.
But you are not mentioned on that day you were present.
Lordship, I missed that. I am not able to.
So what has happened? 29th April?
29th April, the matter is fixed, Lordship, on 8th of May.
8th of May. Come on, 8th of May. I will see to that.
May I be permitted to mention, my lord, one item with regard to item number 6, today's list, my lord. It's a contempt matter, my lord. In this matter, I am appealing for the contempt number 6, 8, and 9. Lordship directed to file the affidavits. Affidavit is ready, my lord. The difficulty is annexers. The annexers has not been properly sealed by the commissioner. That's why the department is not accepting this one. Leave may be granted or
come when the matter call, come on that.
What's your division? Yes, item number 1.
Yeah, for the defendants, my lord, this extension of time for the commission, my lord. Now, my lord,
the commissioner.
My lord, the commission, Mr. Ishan Shah, my lord.
Hmm.
Now, my lord, that is not the difficulty. My lord, the parties, my lord, here, my lord, I was led by my lord, senior, my lord, a senior advocate.
What is the stage of the evidence?
My lord, we are crossing the witness of the plaintiff, my lord.
Plaintiff witness cross-examination going on.
Yes,
Still.
Yes, my lord. It is because there's a lot of time, my lord, we could not do because, my lord, I was being led by, now, my lord, this on my lord's side, my lord, Justice Mitra, my lord. But he was leading me, my lord. After, my lord, he has gone, my lord, there was a difficulty, my lord. So, my lord, kindly extends the time, my lord, in complete, my lord.
Yes, your lordship, from the petitioner, our chief examination has been concluded.
How many witness further you will adduce? Any further witness?
Yes.
Further one witness?
Yes, your lordship. We only have one witness.
No, one witness has been examined with chief.
Yes.
You will adduce any further evidence?
No, your lordship.
No. And you will examine further. You will examine.
Well, we will, my lord. We will, my lord. If at all, my lord, their chief and my lord, the answers if they give, my lord.
So and so appearing for the plaintiff, so and so appearing for the defendant. The matter is fixed today for filing report by the commissioner. Police counsel for the plaintiff submits that examination chief of the plaintiff witness is completed and cross examination is going on. Counsel for the defendant submitted that submitted praise for counsel for the defendant praise for time. Praise for extension of time to file report by the commissioner as the cross-examination is still continuing. Counsel for the defendant further submits that after the examination of the plaintiff's witness, the defendant will also adduce evidence. Consider the submission made by the counsel for the parties. Time to file report by the commissioner is extended. Then vacation
Kindly give still, my lord, the long vacation, my lord.
is extended till
After the long vacation, kindly provide, my
till
lord.
30th July
My
2025.
lord, kindly, my lord,
30
not-
July.
not be possible. Because the vacation is there, my lord. Again, my lord,
Vacation
no one will be there, my lord. Kindly, my lord, provides, my lord, at least August, my lord, end of August, my lord.
26th August 2020.
Grateful, my lord.
ये कल मिला था ना none appears on behalf of the plaintiff. The matter was listed yesterday, but yesterday also none appears. For the interest of the case was adjourned till today. Today also when the matter is called, none appears on behalf of the plaintiff. No accommodation is sought for. List the matter in the list of in the warning list. Place the matter in the warning list. Yes. वो भी दोनों सेम ही कर दो. Place the matter in the warning list.
My lord, I appear for the plaintiff. May I beg your pardon, leave to appear online? Lordship, the plaint was admitted by Lordship's order dated 21st of April 2025. Thereafter, certain objections were raised by the department upon scrutiny. May I have your Lordship's leave to correct the defects raised?
So appearing for the plaintiff through virtual mode. The matter is listed as to be mentioned on receipt of the report from the Office of the Land Master. It is found from the report that at the time of the scrutiny of the plaint, the department has found altogether 4 defects. The counsel for the plaintiff prays for 2 weeks' time to cure the defects, and also prayed for re-verify and reaffirmation of the affidavit if required. In view of the submission made by the counsel for the plaintiff is 2 weeks' time is granted to the plaintiff to rectify.
Lordship, if I may have your Lordship's leave to correct the affidavit without going for reaffirmation of the affidavit.
Cannot.
Grateful.
Affidavit cannot correct. क्या बोला?
We'll go for reaffirmation.
And also granted leave to re-verify and reaffirm the affidavit if any required.
Grateful, Lordship.
Next.
Lord, I appear for the plaintiff.
Yes. Yes.
My lord, if your lordship comes to the first title ones.
Huh?
First title ones.
Yes.
Lord, the defendant resides within the jurisdiction.
Huh?
Defendant is within the jurisdiction, my lord.
Defendant.
Yes, my lord. One is Mango Lane and the other one is Ganeshchandra Avenue. Regional office at Mango Lane, branch office at Ganeshchandra Avenue.
Correct.
Now, my lord, will kindly comes to paragraph 9 at page 3.
Yes.
My lord, this is a policy which was issued in respect of plant and machineries, my lord, from Ganeshchandra Avenue. So, my lord, if the defendant is within the jurisdiction, my lord, I am not required clause 12 leave. My lord, repudiation was also within the jurisdiction, my lord.
Hmm.
My lord, paragraphs 9 and 10, two policies, my lord, both issued from within the jurisdiction.
Correct. Then
Paragraph 20, my lord.
where your plant situates?
My lord, it is in Assam.
So you are Assam.
Yes, my
You are
lord.
claiming damage of your factory
Yes, my lord.
under the insurance claim. Claim was issued in Calcutta, but your cause of action arose in Guwahati with regard to the damage or whatever it is.
My lord, kindly
So
comes,
that is there is no part cause of action.
my lord, but if I'm not mistaken, my lord, if your lordship takes clause 12, my lord,
Hmm.
if the defendant resides within the jurisdiction,
Maybe, but your two cause of action issued here. Factories in the Guwahati.
yes, my lord.
You are claiming the damage of the plant of the Guwahati.
Yes,
So
my lord.
part of cause of action is not there.
Part of cause of
Then,
action.
if the part cause of action in Guwahati, you will not ask
Lord,
for
in
the leave under clause 12.
My lord, we'll amend.
Huh?
We'll amend the plaint. Accordingly, we'll amend the plaint and see.
Then, if it is okay, you reside in Guwahati, but your factory is in Kolkata. Your claim has been issued in Kolkata. You are claiming the damage of Kolkata. That is a different thing, which is jurisdiction. But your factory is in Guwahati,
Yes, my lord.
and you claim the damage of the factory
Yes, my lord.
under the insurance claim.
Yes, my lord.
Then,
Very well. We'll amend the plaint, my lord.
and with regard to the other limitation, how is the
Paragraph
limitation?
30, my lord. Paragraph 30.
Paragraph 30. Yes.
Page 11.
When the reputation was issued?
Repudiation was issued on 11th of November 2020.
11 November 2021.
Yes, my lord.
During the COVID period.
During the COVID period.
Correct. So
So, my
COVID
lord,
period,
according
so
to
you will get the total claim till 31st of March 2022.
No, my
Eh,
lord.
1st of March 2022.
1st of March, the limitation period starts. my lord.
Only the 1st March 2022
Yes,
limitation starts.
Yes.
Correct.
So 3 years from there, my lord,
Hmm.
takes us to 28th of February 2025.
Correct.
Now, my lord, then there were 93 days of period when I had initiated Section 21 notice under the Arbitration and Conciliation Act, Section 11 filed and Section 11 dismissed on the ground that it is not maintainable.
When the section 11 dismissed?
My lord, Section 11 was dismissed on 8th of December 2022.
Hmm.
And then, my lord,
8th of December 2022.
yes, my lord. And then, my lord, from 11th January to 9th March 2023, my lord,
Hmm.
it was pending before the mediation center, my lord, pre-litigation mediation. So, my lord, if your lordship sees the calculation now, my lord, I have a small little calculation over here. I have 151 days, 93 days while Section 21 and 11 were pending, my lord, and 58 days
When you filed this suit?
this was filed
When you
29th April.
29th April. 29th April.
Yes, my lord.
29th April. And you had to file by 28th of February.
28th of February.
28th of February, correct?
Yes, my lord.
So 60 days is here.
I'm sorry, my lord.
61 days is here.
61 days.
61 days is here. Correct?
61 days is
28th February leave aside.
yes, my
The
lord.
March 31
And 29 days of
29. So 60 days.
60 days.
Correct. 60 days.
Yes, my lord.
60 days.
Yes, my lord.
Wow. So how you can 60 days?
My lord, 93
When
days.
when you file the when you file the this mediation.
My lord, mediation was filed on 11th of January 2023.
Correct. Then March 2023. That will not get the benefit. You will not get the benefit.
Subject to correction, I will get the benefit.
23. Now your cause of action till the 2024. How you will get the benefit
Well,
of that?
Kindly comes to the section, my lord, once.
Which action?
12A, my lord, commercial code. Sir.
Ah.
Section 12A, subsection 3, my lord, second proviso.
Correct.
Provided further that the period during which the parties remained occupied with the
Where from you're reading?
my lord, 12A,
Hmm.
subsection 3, second proviso.
Provided that
the period during which the
parties
remained occupied with the pre-institution mediation,
Ah.
such period shall not be computed for the purpose of limitation under the limitation.
Correct.
So, not 58 days.
How you have initiated the mediation process on 11th of January 2023, that is within the limitation period,
My lord.
and your non-starter report has been issued on 9th of March 2023, that is within the limitation period.
My lord.
So how this period can be excluded? If we will say you could have been taken the mediation on 28th of February and it is completed on 20 subsequently thereafter, after the period of limitation, that can be taken. How this period will be
No, my
taken
lord,
into?
uh,
You have waited 2
in
years
my-
after this non-starter report.
In my humble submission, my lord, the second proviso does not provide that. It says that the entire period during which the parties were
I will explain. I will explain. This proviso is not provided to you because you have carried out the you have initiated the mediation process on 11th of January 2023 within the period of limitation, and the non-starter report was issued within the period of limitation, and you filed the suit after the period of 2 years from the getting the report of the non-starter report. How this proviso
well, in that case, my lord,
proviso clause will be applicable
I
to
have
you?
yet another, my lord, section 14 of the Limitation Act, my lord, in respect of the time period when 21 was issued and my section 11 was dismissed.
That you can
93 days, my lord.
Where is that? Which page? Which paragraph?
My lord, same paragraph, my lord. Period of 93 days between 7th.
When you issued the notice?
My lord, 7th of September.
7th September, which year?
2022.
2022.
Yes, my lord. Till 8th December 2022 when the
Correct, 30 days. 7 September to 8 December, 30 days.
no, 93 days, my lord.
After September, okay.
93 days.
How you waited for 93 days?
My lord, from 7th to 8th September.
Correct. Then what has happened?
Then we went for mediation, my lord.
When the AP was filed?
Lord,
When the AP is filed before the court for appointment of arbitrator?
well, AP was filed on 7th September, my lord.
AP was filed on 7th September. When AP disposed of 22nd.
Yes, my lord.
Then that is also within the period of limitation, sir. That is also within the period. Your limitation start from 29th of April 2025. Yes, 28th of February 2025.
Yes, my lord.
And your this section 11 petition was already disposed of.
Lord, subject to correction, my lord. Section 14 also says that this period will be 14(1).
Yes.
In computing the period for limitation for any suit, the time during which the plaintiff has been prosecuting with due diligence another civil proceedings, whether in a court of first instance or of an appeal or revision against the defendant, shall be excluded where the proceeding relates to the same matter in issue and is prosecuted in good faith in a court which from
That's
the
correct, sir. But you have filed the Section 11 application on 7th of September 2022, correct?
my lord,
And your Section 11 petition was dismissed or disposed of, whatever it may be, on 8th of December 2020.
my lord,
That is within the period of limitation.
my lord.
It is not that the beyond the period of limitation.
But in that case, my lord, since your lordship is not with me, if I can come back and satisfy your lordship on this,
Come back, come.
can I come back on
Yes. When?
13th, my lord?
Hmm?
13th.
13th.
My lord, I will be stuck tomorrow and day after, my lord, with some.
So suffering for the plaintiff. The matter is listed as to be mentioned on receipt of the report of the Office of the Master and Official Referee dated 2nd May 2025, wherein it reveals that the suit filed by the plaintiff is barred by limitation. Full stop. Counsel for the barred by limitation, and the plaintiff has also not prayed for leave under clause 12 of the latest patent 1865 as part cause of action arose outside the jurisdiction of this court. Counsel for the plaintiff prays for time. As per this full stop. In view of the submission made by the counsel for the plaintiff, the case is adjourned. Let the matter appear on 14th.
My lord, if I may have a copy of the report, my lord.
And the petitioner, the plaintiff, the learned advocate on record of the plaintiff is given liberty to go through the report of the master and official referee dated 2nd May 2020.
Can I have a copy of it?
The assistant registrar of the court is directed to serve the copy of the report dated in course of the day. Yes.
Much.
My lord, in this matter, I am led by Mr. Naveen Kumar Thakur. He is appearing virtually, my lord.
Yes.
Your Lordship, just I am seeking the liberty of the Honorable Court to appear through VC because, Your Lordship, I am appearing all the way from Delhi, Your Lordship. So, Your Lordship, we are appearing for the alleged contemner number 6, 8, and 9. So, Your Lordship, technically, contemner numbers 8 and 9 are one, Your Lordship, because the companies were merged in the year 2022 only. Makan.com, it was merged with housing.com, Your Lordship. And the website of the Makan.com was also decommissioned in the year 2022 only, Your Lordship.
Okay.
So, Your Lordship, affidavit has been filed, Your Lordship, as per the direction of the Honorable Court. Your Lordship, there are today only just I have noticed that there are some errors in annexures, Your Lordship. Moreover, there are few annexures which have not been notarized, Your Lordship. And that's why the annexures are there without notary. So I will seek liberty of the Honorable Court. I will place fresh annexures on record with the by after following the requisite norms, Your Lordship.
We have not been served with any affidavits.
No, they have not. But you have filed this.
Well, this is the affidavit of service. My lord, your lordship on the last occasion, my lord, had directed my lord us to make, to serve upon them. Your lordship, my lord, comes to the
Have you served?
lordship. My lord. We have served all of them, my lord. All of them have been delivered.
Property wala. Yes. And you are appearing for? Yes, Mr. Thakur, you are appearing for 8 and 9.
6, 8, and 9.
8 and 9. And you are for the 5. What about the 7, 99 acres? 7 services affected?
Yes.
99 acres?
Yes. My lord, service has been affected overall. My lord, your lordship, my lord, if your lordship takes the order once, paragraph 12. My lord, it's a contempt proceeding. My lord, the contemners had come before your lordship and has said that they have already informed these 5 added parties. Today, that was way back. After that, my lord, your lordship gave this direction. Today, my lord, respondent number 5 comes up and says that they need 4 weeks time to file their affidavit.
And they submitted, let the court consider.
My lord, another thing, my lord, the added party number 1, that is property wala, is still carrying on. Number 1. Number 2, added party number 6, Prop Tiger, I just checked up, they are still carrying on. And my lord, on the last occasion, my lord, before Justice Kapoor, when the interlocutory application was disposed of on the basis of their undertaking, they made it clear that it would not be done. And Justice Kapoor also, my lord, made it very clear to them that these my lord, my lord, way of my lord, continuing with advertisements, my lord, in a way out proceeding, my lord, this should not be done. My lord, now today I find something else. Amazon has also started advertising the same one which was injuncted, Siddhi Vinayak Solaris, with the same logo and Just Dial.
Okay. Okay, how soon you will give the affidavit?
Affidavit is already
Notarize,
ready, my lord.
when you will affirm this?
It was affirmed on 30th April, my lord, before in the Delhi, my
So
lord.
you will file today?
My lord, I will file today if the leave is granted without
For what?
the notary seal is not on the annexure, my
So
lord.
that's why when you will complete the notary sealing the
In a
document?
week, my lord,
Week
because
will not grant.
it has to become from the Delhi, my lord.
I will not grant so.
Your Lordship, may I? Your Lordship, there is a humble submission. As far as the allegations is concerned, that we are still carrying on the advertisement of Solaris. Your Lordship, this is not the case. Though we have already filed the affidavit affirming that we have removed, Your Lordship.
That's why this court want to see the affidavit, what you have stated in the affidavit, sir.
So, Your Lordship, affidavit is on record. Though,
Yes.
Your Lordship, affidavit is on record. So kindly, if Your Lordship will grant me, I will just request the Honorable Court to have a Your Lordship, if Your Lordship may kindly have page number 9 of my affidavit, which has been filed on behalf of contender number 6, Your Lordship.
Last one is the 6th one. This one is the 6.
Paragraph?
Paragraph number 4, Your Lordship.
Yes.
Your Lordship, may I read? This is, Your Lordship, I say that in the present case, only on 27th March 2025, the alleged contender received a ticket request. It was ticket, Your Lordship. Nobody given us any email.
Which paragraph? Which paragraph you are reading?
I am reading paragraph number 4, Your Lordship, at page number 9, Your Lordship. Page number 9 of my affidavit.
Correct. I say that.
Please, Lord. So I say that in the present case, only on 27th March 2025, the alleged contender received a ticket request for him.
This may be the one for the 8 and 9. This is the 6 for the 6, my lord.
This is for the 6. And Your Lordship, as far as the affidavit number, affidavit for the contender number 8 and 9 are concerned, Your Lordship, kindly have page number 10, Your Lordship.
Yes.
Yes.
Please, Lordship. So page number 10 and para number 8, Your Lordship. Your Lordship, in this case, we have received a confirmation on 2nd December 2024 to remove the advertisement, and we removed, Your Lordship. As far as the allegation right now is concerned, Your Lordship, this thing we have to understand. We are a digital platform, Your Lordship. Anybody can put the advertisement on our website, sir. Definitely, we cannot restrict anybody, any stakeholder, to for putting up the advertisement on our website, Your Lordship. Either tenant or broker or owner of the property, they can put advertisement, Your Lordship. Definitely, when we receive a complaint regarding any breaches, we immediately take down that advertisement from our website, Your Lordship. So the moment when we received this confirmation that there is a court order, in this case, Your Lordship, we immediately put down the advertisement, and Your Lordship, we received on 2nd December 2024. This is the I'm Your Lordship referring the affidavit filed on behalf of 8 and 9, and on 6th of December 2024, we taken down the advertisement, Your Lordship. Your Lordship, we were not at all aware why we would put the advertisement despite court order. We are not an interested party.
How the advertisement is coming in your website?
Your Lordship, that's for the same, Your Lordship. Just I'm submitting for the Honorable Court that anybody can put the advertisement on our website. It is open for everybody, Your Lordship.
Second one after Amazon. Prop Tiger.
Prop Tiger, housing.com. It is basically, Your Lordship, this is a digital app, digital website available for everybody who can place their property descriptions for letting out the property or for selling their property. Your Lordship, this is open for everybody. The moment when we receive complaint, we take down the advertisement, Your Lordship.
But if any advertisement has come on your website, so you have to see who has put the advertisement in your website.
Please, Your
Can
Lordship.
identify that.
Please, Your Lordship.
You're telling that you have replaced that or you have taken out from your website. So how this again the Siddhavinayak Solaris is in your website proptiger.com on 5th of December 2024?
So, Your Lordship, as far as this part is concerned, definitely I would request the
Yes, sir.
party in interest to supply me the particular page, Your Lordship. We will definitely investigate the case and we will file another affidavit before the Honorable Court, Your Lordship.
Check your website. It is in the website itself. The learned advocate
Your Lordship,
told me.
may I, with your kind permission, I'm appearing for the alleged contempt 1 to 4, the directors of the company. This is the problem that the directors are facing, Your Lordship. It is not within our control. How do I do anything on that? Number one. Number two, Lordship, the submission is made that anybody can come and do it. But if I want to advertise anything on any website, I have to open an account. I have to register myself. Without that, I cannot do. On the last order, Your Lordship, you directed that they must file an affidavit showing that there was a contract between them and the alleged contempt numbers 1 to 4 of the company. That has to come forward. Whether was it done by us or was it done by they themselves?
They don't disclose who has put up the advertisement. Well, it's a half-constructed project. So it could not have come from someone who has purchased it and now selling it.
Your Lordship, of course, we are not at all interested party. We are not going to derive any benefit. So we are not a property dealer. We are not a purchaser. Definitely, we are not going to derive any benefit. So, and
Why, if you're not getting any benefit from that, so why you are allowing the persons to continue to give the advertisement from your website?
so, Your Lordship, today only I received, because I have already placed on record my affidavit saying that on the particular date.
On the last occasion, when the matter, the original contemners, they have stated that they have not given. That's why I made all of you as a party. Now you are telling that you have withdrawn. Now I find that still it is going on. Still
So,
it is going on. So
Your Lordship, kindly allow me a week's time, Your Lordship.
please instruct your client, if this court find with regard to on the next date, I find any of the advertisement after
Please.
the order, after your affidavit, then your client has to face the consequence.
I'm seeking
Yes.
apology for this, Your Lordship. I will definitely instruct my client.
I have not passed an order for the appearance of your client. If I find that not appearance, then your client has to face the consequence.
Please, Your Lordship.
And
Please.
before filing an affidavit, you being the advocate, you check whether you check the website whether it is there or not. The client may say something, anything.
Please, Your Lordship.
Actual will be different. Then you will be in difficulty by affirming affidavit.
Please, Your
How
Lordship.
often you will file this affidavit?
My lord, by Monday I will file, my lord, because today is the Tuesday.
Up
Wednesday.
tomorrow, day after tomorrow.
Well, only one thing I must
It has
point
to be
out to your
come from the
lordship.
Delhi, my
Well,
lord.
your
That is
lordship
the
takes the
difficulty.
paragraph 12. Well, none of the requirements have been complied
That's
with.
why because this is not been, let
Very-
it come. This court is harping upon let the come on black and white in the
And
court.
one more submission which my learned friend had made, that they came to know in December and sometimes in March.
December itself, we have
No, second, as per their submission, the second
2nd
December it has
December.
been removed.
6th December. it has been-
6th December we removed, Your Lordship. 2nd December we just got the confirmation, and on 6th we removed.
File the affidavit, let them file the affidavit.
Your Lordship, the 4 directors are personally present here, Your Lordship, that can be recorded.
They may present because they have created all this
Lordship.
problem. They have to present before this court.
Lordship, also one small request. If the
If they
affidavit
wanted
can be
to
served
do,
to us also.
if
copy
they
of the
wanted to
affidavit.
pursue their business, why you are taking the benefit of the other advertisement?
Well, no,
And
Amazon
all the complications has come here because of them only.
Now
Lordship.
adjournment comes up, just dial.
All the groups should go up one place, which is a better place to have a conference.
Yeah.
Good place I will send. So have a good conference with them. This 4 persons, other 6 persons.
It was made clear by Justice Kapoor.
I will send a
Clearly
good
not
place.
Not to
No
get around
requirement
this
of
way.
any food, any tea, and all these things.
It was made clear to them.
Free of cost, this court will provide all these things. So appearing for the petitioner, so appearing for the alleged contender number.
6, 7.
No, you
1 to 4.
1 to
4.
1 to 4. So appearing for the alleged added content number 5.
6, 7, 8, and 9.
So appearing for the alleged content number
6, 8, and 9.
6, 8, and 9. Full stop. None appears on behalf of the alleged contender number
7.
alleged contender number 7, namely 99acres.com. Plaintiff has the petitioner has filed affidavit of service showing that the notice have been issued by the alleged contender number 7, but none appears on behalf of the alleged contender number 7. The alleged contender number 7 is directed to appear before this and let rule be issued upon the alleged contender number 7 for appearance of the alleged contender number 7 before this court in person on the next date fixed. So the petitioner is directed to take appropriate step for issuance of rule. Full stop. As regard the alleged content number 5, 6, 8, and 9. What about your affidavit? 5? Alleged counsel appearing for the alleged content number 6, 8, and 9 submit that their affidavit is ready, which has been notarized at Delhi, but inadvertently in the annexes, it has not been annexes have not been notarized, and in the annexes the notary public has not put his seal in the annexes, and he prays for time to rectify the affidavit, and after rectification of the same, the affidavit will file before this court. Counsel for the alleged content number 5 prays for a week time to file affidavit. Consider the submit full stop. Counsel for the petitioner plaintiff submitted. Still, the alleged contenders are publishing the advertisement in spite of the interim order passed by this court. Consider the submission made by the counsel for the respective parties. The alleged content number 5, 6, 8, and 9 are directed to file their affidavit in proper form by by 15th June 2025 and 15th May 2025. After serving the copy to the learned counsel for the petitioner, the petitioner is liberty to file reply to the said affidavit by 21st of May 2020. Vacation is by 21st of May 2025. List the matter under the same heading on 10th of June 2025. 10th of June.
Just one more submission. It pleases to your lordship, my lord, let the contenders numbers 1 to 4. My lord, give an affidavit explaining as to why it's appearing in Amazon.news and my lord, Just Dial.
Yes, they have sent to the
Recently started.
counsel for
Your lordship, as in when we are able to find out, we are not doing it, first
counsel
of all,
for
your
the
lordship.
petitioner submit that. The petitioner also found that the advertisement is being made in the Amazon. What is the website?
Amazon website. Amazon AWS.com.
AmazonAWS.com. Full stop. stop in spite of the
Your Lordship,
not a
may I,
passport.
Your Lordship, may I, may I? Your Lordship, we have already sent a mail to Amazon AWS and they have replied that they cannot do it.
Full stop. The counsel for the alleged content number 124 submits that they have already sent a mail to the Amazon
That's why we are finding we are doing it, but unfortunately it's not in our control.
restraining for publication of any advertisement, and on receipt of the said communication and communication of the said and on receipt of the said communication, Amazon.com has sent a reply to the alleged contender that they are not using the not publishing any advertisement in their website. Full stop. Considering the submission made by the counsel for the respective parties, the alleged contender number 1, 2, and 1 to 4 TO2 1 to 4 are directed to file the affidavit stating that they have not stating whether to clarify file an affidavit by clarifying that whether they have used the website of Amazon www.aws.com for publication for advertisement of the properties of the plaintiff by using the using the using the word Solaris within a period of 2 weeks from date. Full stop. Let the matter appear on 10th 10th June 2025.
Also just dial.
वो जो बोला ना Amazon जो जगह बोला है ना, as well as justdial.com. Just dial करो.
Great for you, Lordship.
Much obliged, Your Lordship.
वो वापस कर दो ओरिजिनल एप्लीकेशन. Yes.
Lordship, this is my suit, Your Lordship.
Yes.
My lord, this is against issuance of debit note by the defendants, my lord.
Huh?
This is against an issuance of a debit note issued by the defendant, my lord. My lord, the registered office of the defendant is within the jurisdiction of this honorable court, my lord.
Within the jurisdiction of this court, and plaintiff is outside.
Yes, my lord.
Yeah.
Plaintiff is outside the jurisdiction, my
When
lord.
the last payment was made.
My lord, the last payment was made on, my lord, 16th October 2023, my lord. It's at page 129, my lord.
16th October. Where is the
2000
pleading?
My lord, it's at page 5, my lord, paragraph 14, my lord.
Sent the email along with the debit note. Also, the control which is making such has been issued. Dependent also paid 1,77,000 on 16 October 2023. Yes.
That is the document which I was relying upon, my lord.
Hmm.
That is at page number 129, my lord. 129, my lord.
29.
Yes, my lord.
Correct.
My lord, we'll see, my lord, at the bottom, my lord. It's 16th of October, 1,77,709, my lord.
Correct.
And my lord, the debit note which I'm against, my lord, it's at page 128, my lord.
128.
Yes, my lord. This is the debit note, my lord. 42,79,696, my lord.
Who has issued?
My lord, this has been issued by the defendant, my lord.
Who is the defendant?
SRMB, my lord.
SRMB is the defendant here.
Yes, my lord. SRMB. Street
SRMB is
Private
filing a case against all of you, and you have filed a case against SRMB. Yes. Where is the non-starter report?
My lord, I don't have it.
Huh? Non-starter report?
Yes, my lord. The report of the my lord is asking for the mediation. Yes, my lord. It's at page 141, my lord. Annexure P, my lord.
February 2024. Plaintiff has filed the suit praying for a decree of sum of rupees 42,79,697 along with interest at the rate of 18% per annum. This court find that the defendant has made the last payment to the plaintiff on 16th October 2023. The plaintiff has also initiated pre-mediation process against the defendant and non-starter report was issued on 26th of February 2024. 26th February 2024. Consider the submission made by the counsel for the plaintiff for use for pleadings in the plaint. Plaint is admitted subject to scrutiny by the department. Next.
Grateful, my lord.
Suit for recovery of claim on account of goods sold and delivered, wherein I have prayed for my lord leave under clause 12, my lord.
Clause 12.
Yes, my lord. When my lord yesterday night when I got the brief, my lord, at least I found, my lord, some mistakes are there, my lord, that need be corrected, my lord, before we platter it before your lordship. So, my lord, may I be given the liberty to file it afresh, my lord, with those
Withdraw.
corrections? Yes, my
You
lord.
want to withdraw this?
And on the to file on the self-same court fees, my lord, and nothing else, my lord.
Census and Supreme for the plaintiff. The matter is listed under the heading presentation of plaint. When the matter is called for, when the matter is called, learned counsel for the plaintiff submit that there are technical defects in the plaint and which cannot be cured by way of amendment, and as such he prays for withdrawal of the suit with the liberty to file afresh on the same cause of action by using the same court fees. Heard the learned counsel for the plaintiff produce the print. Plaintiff is granted liberty to withdraw the suit with the liberty to file afresh. Accordingly, CS Conf 54 of 2025 is dismissed as withdrawn, liberty to file afresh on the same cause of action. And the plaintiff has given liberty to use the same court fee if the plaintiff files the new suit on the same cause of action.
I'm grateful.
Well, it's kind leave to present a plaint, my lord. I'm praying for dispensation under 12A. Now, the facts are extremely, my lord, different in this matter, my lord.
Yes.
My lord, this was a case where an agreement was entered into between, my lord, the defendant number 1 and, my lord, the other defendants. My lord, for defendant 1 and 3 for obtaining financial assistance for its business purpose.
When is obtained?
But that was obtained long back, when I'm 2023. But the issue is, I have been impleaded in that agreement in the capacity of co-borrowers using my digital signatures, to which I have never consented to. My lord, this defendant number 1, which is a finance company, not NBFC, had gone before a Section 9 court of this honorable court, my lord. In a Section 9, the Section 9 application has been dismissed on the ground that they have nothing really against us. My lord, we have now filed this suit praying for delivery and cancellation of that agreement. But why the urgency is, defendant number 2 is, my lord, civil. Because of that agreement,
Defendant number 2 is
civil. Because of that agreement, my lord, my civil score is being affected, my lord, severely, though the entire money under that agreement was paid by the principal borrower. So, my lord, I am in requirement of seeking urgent interim reliefs because my civil score is getting hit and my entire everything is being, my lord, hampered and I'm unable to obtain loan. My lord, there are 4 plaintiffs. You lost 3 plaintiffs. And, my lord, all of them are being affected by this act on the part of the defendant number 1 and 3. So that is why, my lord, I need to, my lord, move an urgent interim application, which we shall be filing in course of the day, or, my lord, tomorrow, my lord, for obtaining.
where we are urgency of pleaded, sir?
Yes, para 22, if your lordship can it is. No, 24. At page 11 of the plaint. well, also one indulgence, my lord, I would be humbly beseeching your lordship. This was filed on an urgent basis, my lord, because of this issue. My lord, we need leave of your lordship under Order 11, Rule 1(4), where in case of urgent filings, the plaint
Document.
would not contain, if it does not contain documents within 30 days, I need to file. But we shall file it in course of a week. But these are the civil reports of the plaintiffs, which shows decimal score, and the only account in respect of which this score is of the defendant number 1's account. This should have been there in the plaint, but this is not disclosed. But I am humbly beseeching if your lordship kindly grants me leave under Rule 4 of Order 11, Sub-Rule 4 of Order 11(1). Could I show that order of Section 9, where your lordship will get the entire facts in a nutshell? The Section 9 code dismissing the
Where is that?
265, the second volume, my lord. Second volume, 265. We were added as parties, but the entire Section 9 application dismissed, no appeal preferred. (265), your lordship. Our submission is at page 269. The plaintiff in this suit, my lord, who were added as respond numbers 226. 269, the paragraph, Mr. Avasthi, that paragraph.
So you are the party in the agreement.
I have been shown as a party in the agreement, no money disbursed to me,
But if you're-
disbursed to the company.
if you're party to the agreement, then how the suit in the arbitration goes?
But I am saying it's a fraud. It's a fraud, and I have prayed for delivery and cancellation of that agreement. I say that my signature was obtained. It's not my signature, it's a digital signature of mine, which were not put in there, and I shall show from the agreement. Your lordship will not see my sign anywhere. My digital signatures have been imprinted on the agreement.
Where is that?
Yes, page 72, my lord, kindly sees. On all pages from 71. In fact, on all pages. My lord, it really starts from, my lord, page, my lord, 63. Your lordship would see at the bottom only digital signatures on each page. Your lordship would not find in any of the pages.
So when you came to know about this?
But when the Section 9 was filed, for the first time we came to know.
And this agreement relied by the defendant.
This agreement,
This agreement relied by the defendant.
relied by the agreement. This is the basis of the Section 9 application, which has an arbitration clause. But I am praying for delivery and cancellation of this agreement, which, my lord, a court has to do, my lord, under the Specific Relief Act, under Section 31. The arbitration clause, I must show, page 66, clause 15.
Correct.
Neither of the petitioners are plaintiffs are directors. Neither of the plaintiffs are directors in that borrower company, in the defendant number 3 company.
Yes.
And my lord, leave your lordship kindly grants to disclose the additional documents.
So and so bring for the plaintiff. The plaintiff has filed the present suit, praying for a decree declaring that the purported document dated 25th of July 2023 as null and void and not binding upon the plaintiff and other consequences of its. Full stop. The plaintiff has prayed for leave under clause 12 of
12,
clause 12 of the
section
latest
12.
patent. Clause 12 also.
Clause 12, section
Clause 12 latest patent 1865, order to rule 2 of the CPC as well as dispensation of requirement of section 12A of the Commercial Code Act 2015. Full stop. Counsel for the plaintiff submitted that the defendant number 1 has filed an application under section 9 of the Arbitration and Cancellation Act before the coordinate bench of this court. Being, where is the order?
265, your lordship, second volume.
265.
Yes, 265.
Before the coordinate bench of this court, being APCOM 39 of 2023, but the honorable court has rejected the said application on 12th of November 2024. Counsel for the plaintiff submitted in the said application, the defendant number 1 had made the plaintiffs were also as party to the said application, and from the said application, the plaintiffs came to know that the defendant is relying upon the agreement, facility agreement dated 25th of July
25th July
25th
2023.
July 2023, which contains the digital signature of the plaintiffs. But the plaintiff submit that the said digital signature which the defendant number 1 is relying upon is not the signature of the plaintiff. It's not.
No, his digital signature obtained by fraud.
And digital and the said has been obtained by the defendant number 1 fraudulently.
1 and 3 fraudulent.
Huh?
1 and 3 also. The principal borrower also.
Defendants number 1 and
1 and
3 fraudulently. Police counsel for the plaintiff submit that there is an urgency to move this application without going into the pre-mediation process. And at this stage, if the plaintiff will be directed to, if the plaintiff will go for the pre-mediation process, the defendant will encash.
No, the civil
and defendant
number 2.
The defendant number 2, who is defendant?
Civil.
The defendant number 2 and the civil limited will take appropriate steps against the defendant which cannot be compensated later on. Counsel for the plaintiff submitted if this court will allow this the prayer for dispensation of section 12A of the Commercial Code Act, the plaintiff will immediately move an application for interim relief. Heard the learned counsel for the plaintiff peruse the materials on record. This court finds that the part cause of action arose within the jurisdiction of this court and part cause of action arose outside the jurisdiction of this court. Accordingly, under clause 12 of the latest patent 1865 is granted. The plaintiff has also pleaded that the plaintiff has filed the suit in an urgency, and as such there is every chance that further damage can be claimed by the plaintiff, and accordingly he has prayed for and accordingly plaintiff is granted leave under order to rule 2 of the CPC. This court find that the plaintiff has categorically pleaded the urgency, and this court find that if at this stage the dispensation of leave under clause 12 under section 12A of the commercial code is not granted to the plaintiff, the plaintiff will suffer irreparable loss and injury. Accordingly, leave for dispensation of section 12A of the commercial code act is granted. Full stop. The counsel for the plaintiff submitted the plaintiff has filed the suit in an urgency, and as such the plaintiff could not disclose certain documents.
Disclose the civil reports of the plaintiffs.
Civil reports of the plaintiff and he prays for leave to allow the plaintiff to file the civil report within a period of
7 days.
within a period of 1 week from date. Consider the submission made by the counsel for the plaintiff. This court finds that the plaintiff has filed the suit in urgency and the plaintiff is granted leave to file the civil report of the plaintiff within a period of 1 week from date.
I'm extremely.
Plaintiff is admitted subject to scrutiny by the department.
I'm appearing for the defendant.
Yes.
I've already addressed your lordship
Yes.
on the aspect of, my lord, the exclusion clauses in the policy. I have shown your lordship the judgments also on which I rely on. Now, my lord, I come to the claims. Because, my lord, the repudiation, your lordship will remember, was on the basis of the exclusion clause. That, my lord, I've dealt with exhaustively. Now, my lord, so far as the matter of claims is concerned, your lordship will kindly once come to the prayers in the plaint.
Yes.
Well, your lordship will find that the first, my lord, prayer is for a decree, my lord, on the basis of, my lord, the amounts mentioned in paragraph 58. I shall come to that. But, my lord, this includes, my lord, the amount of the claim that has been repudiated. There are other aspects of loss also. Now, my lord, paragraph B, prayer B is, my lord, inquiry. C is, my lord, what I'll address your lordship on today. Please see, my lord, C is declaration that clause numbers 4, 5, and 6 appearing in the deterioration of stock potatoes at cold storage policy be declared as void, non-est, inoperative. Now, my lord, if these, my lord, clauses are applied, then, my lord, my claim will be significantly reduced. Now, my lord, what are these clauses? May I quickly show your lordship that? Well, if your lordship will kindly have a look at, my lord, the judge's brief, my lord, which is the final compilation at page 79.
Yes.
Well, your lordship will find, my lord, item number 3 is claim settlement.
Correct.
And under claim settlement, may I just read this? All claims shall be settled on the basis of the insured value or the market value, whichever is less, and appropriate deductions shall be made therefrom in the following order. Now, my lord, so, my lord, insured value or the market value, whichever is less. Here, my lord, the market value has been found to be much higher. So, my lord, automatically I get, my lord, the lesser insured value, although my obligation to pay the farmers will be at the market value.
All claims shall be settled on the basis of the insured value or the market value, whichever is less.
Right. Now, in this case, it is on record that the market value at the relevant time of the loss has been found to be much higher. So, my lord, the insured value is, my lord, what will operate. But, my lord, the problem is, my lord, of course, this is not, my lord, your lordship's concern. I, as the, my lord, cold storage owner, will still be obliged to compensate the farmers at the current market value. That is the law. My lord, now, my lord, coming back, my lord, kindly see, my lord, shall be made of deductions shall be made therefrom in the following order. What are the deductions? Shrinkage, rottage, as stated here under. Value of damaged stocks as ascertained at the option of the company by sale or survey. Under insurance, excess, recovery. Now, my lord, kindly note, my lord, so far as excess is concerned, it is said excess stated in exception number 1. Now, my lord, please see shrinkage first. Now, my lord, shrinkage, the amount to be deducted from each claim value for shrinkage will be in the same percentage as stated in the insured's contract with the hirers, or 5% of insured value of the damaged stocks, whichever is higher. My lord, may I just pause here for a moment? What this means is, my lord, today, for example, my lord, if I keep, tomatoes in the cold storage, over a period of time, the moisture dries up. So, there is shrinkage in weight and quantity. Similarly, in the case of certain fruits, potatoes, etc. Now, there is an estimation made by the government as to what will be the percentage of shrinkage considered for each matter. So, that is what shrinkage means. And here the clause is, it will be calculated at the percentage stated in the contract with the hirers. Now, the contract with the hirers in our case mentions no percentage, or 5% of the insured value of the damaged stocks, whichever is higher. Now, this is therefore they have claiming it at 5% of the damaged stock. Then, please see rottage.
So insert contract with hirers or 5%.
Yes. Now,
So
there is no contract with hirers which provides for what the
5%.
string. So 5%. Well, then, please see rottage. The amount to be deducted from each claim value for rottage will be 5% of the insured value of the damaged stocks, irrespective of whether the contract of the insured with the hirers provides for such deduction or not. So, they say also there will be rottage 5%. So 5% goes on shrinkage, 5% goes on rottage. And then, please see excess. Amount specified in Schedule 2, being the loss stated in Clause 1 of exceptions of this policy, which the insurer himself is to bear. Now, here, so far as excess is concerned, it says, amount stated, please see, in Schedule 2. Amount specified in Schedule 2.
Being the loss stated in Clause 1, exception of the policy which is insured. Yes.
Right. Now, please see Schedule 2, which your lordship will find at page 73. 73 to Naki.
73 is the.
Well, this is, I am told, of course, I have not been able to find, but I am told that this is, the only, reflection of the excess. Well, it is, said the policy schedule. Well, this is the schedule to the policy. This does not specifically refer to Schedule 2.
Which page? Schedule?
73. I'm sorry. Well, this is, yes, 73 of the compilation of the judge's brief.
73.
Well, does your lordship have, deterioration of stocks? Kindly see at the top of the page. Well, your lordship will find just on the symbol, on the stamp, deterioration of stocks, potato policy schedule.
Correct.
2. So, this is the schedule 2. Now, please see, now, so far as this, risk details, then the stocks of potatoes mentioned after that. Cool room number 1, description of goods, rate, maximum stocks, sum insured, and then excess, is nil.
Excess 0.
0. Now, this is what we find. So, there is a provision for shrinkage. There is a provision for rottage, both 5%, 5%, and excess, but excess is mentioned as 0. Now, what has the surveyor done? Well, if your lordship will kindly see, the survey report starts at page 134.
Hey, volume 2,
Well, it's the survey report of the stock deterioration policies at state page 134.
Yes.
Now, if your lordship will straight away come to page 151, which is the adjustment that the surveyor is making. Of course, after this whole exercise, surveyor said I repudiate the whole claim. But
Page
that's,
number?
well, at page 151.
Yes.
Well, please see calculation of net adjustment of loss. Now, your lordship will find number of bags, policy, etc. all mentioned. Then less shrinkage at 5% of value of potatoes.
3,90,000. Yes. 339,61. Yes.
Yes, my lord. And then, my lord, less rottage. My lord, again 39,61,458.
Correct.
And then, my lord, kindly see excess, less excess. All the excesses, my lord, nil.
But he has taken 10%.
Yes. So, my lord, 20% deducted straight away. Now, my lord, the question is, my lord, these terms, my lord, this term, my lord, with regard to.
So there is no dispute with regard to the shrinkage and rottage.
No, no.
5%, 5%.
No, my lord, I am, my lord, your lordship, remember, I am challenging the clauses. The clauses provide for 5%.
You are challenging, but as per this.
Yes. No, there is no dispute.
Non-dispute.
Well, if today your lordship accepts my challenge to clauses 4, 5, and 6, then there is a dispute. Otherwise, there is no dispute. Now, my lord, so far as this is concerned, my lord, if your lordship sees so far as excess is concerned, that is disputed.
Yes.
Now, my lord, so far as this is concerned, please, my lord, for a moment, my lord, consider one thing. Well, your lordship has seen earlier, and well, I shall just show your lordship again, that my lord, ultimately the government, my lord, fixes, my lord, the insurance company. First, the government says that these are the companies from which you will take insurance. Now, my lord, these insurance bond contracts are all standard dotted line contracts. I have no, my lord, negotiating
The
power.
government, yes.
Yes. Number 3, these are the terms which are imposed on me. Now, my lord, the question is whether these terms are unfair, because that is, my lord, where the law will come in. Now, my lord, a term is unfair. Your lordship has seen, my lord, particularly in insurance contracts, my lord, when, my lord, it is, my lord, dehors the main purpose of the policy.
Correct.
The main purpose rule is, my lord, what is ultimately the Supreme Court has held must be, my lord, the rule applied for deciding the efficacy of the exception or exclusion clauses. Now, my lord, that is also the rule on which, my lord, construction of clauses has been followed, and to the extent of, my lord, applying what we have now come to call the blue pencil theory, that you strike off a clause.
Correct.
Because it's unfair.
Deleted, yes.
Yes. Now, my lord, here, my lord, the purpose is, kindly see, the purpose is ultimately to benefit the farmers. Why? Because if I carry on, my lord, a cold storage business, and, my lord, there is loss to the produce that is stored by the farmers, then, my lord, I will not be able to compensate the farmers. Now, that is why the Cold Storage Act mandates, obligates,
Insurance.
you must have insurance. And when it also says you must have standard insurance policies, in the sense that it specifies that these are the insurance companies from which you will take the policy, determines the quantum of premium. Now, well, in this regard, may I just request your lordship to kindly just have a look at, well, the two documents which I had already shown to your lordship earlier. Government. Well, at Exhibit 1A, yes. Page number 1A. Page number 1A, my lord. Page number 1 and page number 42. 1A text, it's same thing. Oh, achha. My lord, please see page number Exhibit 1A.
That is a notice.
Yes, my lord. Now, my lord, this is the notice,
Yeah.
my lord, on the basis of which a meeting is held. And then, my lord, ultimately the direction that is given, that is the next document, minutes. The notification to go. Well, this is the notification. This is the notification. Well, let kindly see the notification. The notification, my lord, is important.
Page.
Well, at page 1A. This is the, my lord, important document.
Page.
This is the directive.
Page 1A.
Page. Well, your lordship is looking at the plaint probably. My lord, I'm looking at the judge's brief.
Judge's brief.
The judge's brief, my lord, it is Annexure A, page 1A. Volume 1.
1A.
But does your lordship have a notice there?
Notice.
Yes, my lord, that is the document.
That is the.
Yes. Now, my lord, this is a notice of, my lord, the Agricultural Marketing Director. It says, in exercise of power conferred upon the licensing officer under Section 19 of the West Bengal Cold Storage Licensing and Regulation Act and rules such and such, then, my lord, kindly see, it says, well, a decision taken in meeting held on 23rd March 2020 and 29th March 2022 regarding fixation of price of potato for insurance coverage. All licenses of potato cold storage of West Bengal are hereby instructed to cover DOS and FOS policies. Now, my lord, this is important. At the price of rupees 1370 per quintal of potato during the year 2022. Now, my lord, this 1370 is broken up into two components. In this respect, the rate of calculation of premium of DOS and FOS policy would be at rupees 0.708 and 0.2065 per 100, respectively. Maximum pro rata charge allowable for realization would be 12 rupees 50 paisa per quintal of potato. So, my lord, I can charge, the insured value is 1370.
Correct.
I can charge only 12 rupees 50 paisa per quintal.
Per quintal.
Yes. Now, my lord, here, so far as this is concerned, my lord, there is also, my lord, a meeting. Rent, meeting. My lord, please turn the page. My lord, next page 1B. Well, Lord, here your lordship will find, well, Lord, this is, my lord, what was discussed at the meeting. At the head of the page, your lordship will find proceedings of meeting.
Yes,
Well,
the same, yes.
Yes. Now, my lord, kindly just see the, my lord, bottom portion after the table.
Yes. After reaching the
Well,
consensus.
Lord, now, my lord, the last 3 lines. The House reached at a consensus that maximum pro rata charge will be calculated on rupees 1370. Now, my lord, this is important. 1200 being per quintal prevailing wholesale price of potato, plus 170 per quintal average cold storage rent. So, my lord, 170 out of these 1370 is cold storage rent. Now, on cold storage rent, there cannot be any excess, there cannot be shrinkage, there cannot be rottage.
House reached the consensus of maximum pro rata charge would be calculated 1370.
1370.
Correct.
But 1370 is broken up into 2 parts.
2 parts. One is the per quintal prevailing wholesale.
Yes.
And
one is the cold storage rent.
Correct.
Now, on the 170 rupees, which is the cold storage rent, there cannot be any application of shrinkage or rottage. It is only on the potato that's stored. Now, that insured value cannot ultimately be subject to any deductions because that is linked to the
Yes.
produce. Now, here, now your lordship will kindly see, the surveyor's assessment here. At page 151, না যেখানে জাস্টিফাই করেছে ওটা কোথায়?
Yes.
হ্যাঁ কোথায় আছে ওটা? না এখানে যেখানে বলেছে যে ওই আমাদের এটা দিতে হবে I'm sorry, please see page 149. This is what the surveyor has said. (149). This is part of the final survey report. The policy rate or insured rate of premium to be charged and fixation of price of potatoes for insurance for a loading season is decided by a holding meeting wherein all party concerned are present, including state government official, representatives of public sector insurance company, and members of Farmers Association. We have received copy of the meeting. I shall not read that. That's reproduced. Then, my lords, next paragraph.
Lodge.
Claim lodged by insured is 685 per bag. 685 per bag of 1372 per quintal at policy rate. Now, my lord, kindly see the market rate. It should be market. It's written as marker. We abstracted market rate of potatoes from the website of Ministry of Food Processing Industries as on 19th May 2022 for Burdwan location. Market rate was 2140 per quintal, which is much higher, 1372 and 2140. That is 1070 per bag. We also noted that the additional district magistrate directed insured to pay compensation at the rate of 900 per bag.
Bag is half quintal.
Now, my lord, 1 bag is half quintal. So, my lord, 1370 per quintal is the insured value. My lord, here, my lord, the market rate is determined at 2140. And my lord, ultimately, it is directed to pay compensation to farmers at 900 per bag, which is, my lord, 1800 per quintal. So, my lord, already am suffering a loss here because that is what I have been directed to pay. Even in that case, the policy rates would be lower than the market rate. Further, against the order of the ADM, insured filed a case in the Honorable High Court at Calcutta, set aside the order of ADM. My lord, I had challenged the, my lord, direction to pay them at a particular rate. My lord, then, my lord, we had also, my lord, in this regard, made payment of, my lord, more than, in excess of 3 crores of rupees. My lord, that is there. My lord, take it. Now, my lord, there is a challenge, but my lord, ultimately, this is, my lord, still subsisting. So, my lord, I have already made substantial payments. Now, my lord,
what has happened after the setting aside the order of the ADM?
Well, ADM, my lord, initial order was set aside.
Correct.
Then, my lord, they, my lord, reassessed it. My lord, I have challenged that again. But, my lord, the court directed me to pay the entire assessed amount. My lord, pending the challenge. So, my
You
lord,
have been directed.
Yes, I have paid that also.
To the farmers.
Yes, well, because, my lord, the court said the farmers is a priority. You can't trifle with their lives. Well, I have paid that. Now, my lord, at the end of the day, my lord, what I am trying to impress, all this is for the purpose just showing your lordship that, my lord, kindly see the object behind the insurance. The object is to insure the farmers. Now, my lord, the farmers, my lord, will be insured, my lord, for the full value of their produce, minus, my lord, rottage and shrinkage. Now, my lord, so far as rottage and shrinkage is concerned, clauses 4 and 5 is there. Now, my lord, please see the schedule 2 once again. My lord, schedule 2, my lord, which your lordship will find.
73.
My lord, that is, my lord, the schedule to the policy. Now, my lord, the schedule 2, my lord, to the rules. My lord, there is the Cold Storage Act and the Cold Storage Rules. My lord, let me first, my lord, show your lordship the Cold Storage Rules, then I shall come to the Act. My lord, your lordship was handed up, my lord.
Yes, yes.
A book was handed up. I don't know whether it's there with your lordship or not.
Book hai? Insurance regulatory? What you have given?
Well, I'm talking of the West Bengal Cold Storage Licensing and Regulation Rules.
No.
এখানে কি আছে? তুমি একটা কাজ, my lord, may I do something? My lord, may I just hand up the iPad to your lordship? I shall, my lord, make a printout and give it to your lordship's office. I think a book was handed up, but my lord, kindly do not.
Book mein to nahi rakha.
Actually, schedule to खुलो. My lord, kindly allow me to open the schedule. না, হ্যাঁ ঠিক আছে। একদম last page.
ये देखो, ये दो control orders तो essential commodities. Yeah.
Yes, my lord, that book. Now, my lord, please see, my lord, the cold storage rules, the West Bengal Cold Storage Licensing and Regulation Rules.
1967.
1967. My lord, kindly come to the last page of the rules straight away. My lord, that is the said schedule 2.
Yes.
My lord, lordship has the schedule, my lord.
Which page? Page.
My lord, this is, my lord, I don't know, my lord, pages will not tally, but this is schedule 2 wide rule 13. My lord, may I just find it out for your lordship? Forms it for it.
It is. Yes.
Now, my lord, please see, my lord, this is, my lord, the statute and the statute rule which says, my lord, what is the maximum loss allowable? Now, my lord, maximum loss allowable in weight or bulk due to dryage or shrinkage.
Yes.
My lord, there is no provision in the regulations for rottage, none whatsoever.
Potato, cabbage, maximum loss.
Now, my lord, potato, my lord, please see, my lord, period of storage. If the storage period is more than 5 months, then 3%. 6 months, 4%. 7 months, 4 to 5%. 8 or 9 months, 5%. Now, my lord, in our case, my lord, so far as the loss is concerned, my lord, here, my lord, the potato was loaded on March 2022. That is paragraph 3 of the plaint.
Yes.
And my lord, the date of loss is 19th May 2022.
3 months.
So March, April, May, my lord, 5 months period has not crossed. So my lord, there is no question of applying any shrinkage in terms of schedule 2.
Yes.
There is no question of, my lord, including in the policy, my lord, any provision for, my lord, deduction of or adjustment of rottage,
Yes,
because that is not, my lord, provided.
yes.
And where excess your lordship has seen is 0. Now, my lord, nonetheless, my lord, there is this clause 4, 5, and 6 of the policy, which, my lord, if I cannot assail before your lordship, ultimately, my lord, these are the deductions that I will have to subject myself. And, my lord, this is very significant deduction because the total claim is reduced by 20%.
Yes,
5 for shrinkage, 5 for rottage, 10 on excess.
correct.
Now, my lord, I had, my lord, earlier shown to my lord, so far as these clauses are concerned, my lord, there is, my lord, as your lordship knows, my lord, no independent, my lord, negotiating, my lord, ability for, my lord, the company, my lord, which ultimately is the beneficiary of the insurance policy. And, my lord, particularly in view of the government mandate, my lord, I have to go to specified insurance companies, take it in their standard format, and ultimately abide by whatever they say. If I say I will not take it, my lord, ultimately my license will be cancelled because.
But the only question is whether subsequently you can challenge that.
My lord, here, my lord, I shall show you, lordship. My lord, here, my lord, if your lordship will kindly have a look at, my lord, may I show you, lordship, one judgment which I had earlier referred to, and my lord, I shall come back to the others thereafter. Very correct question. My lord, please have a look at, my lord, the judgment, my lord, reported in 2023, Volume 1, Supreme Court Cases 428. Well, I think, my lord, that was already handed up. My lord, this is the Texco marketing case. Actually, it's there.
Yes, taxonomy.
My lord, please have a look at, my lord, here, my lord, paragraph 22, I think. Kindly give me a moment. Right, yes.
Twelve, 13, 14.
Yes, my lord, 12, 13, 14.
That is the exclusion clause.
Yes, my lord. My lord, what I want to show your lordship is, my lord, to try to answer your lordship's question. Now, my lord, kindly have a look at, my lord, paragraph 22 onwards. My lord, because your lordship has, my lord, asked me whether we can challenge subsequently. That is the question.
Yeah, that once
Yes.
you accepted.
Yes, yes. 22.
Yes.
My lord, may I just read, my lord, these few paragraphs? On a discussion of the aforesaid principle, we conclude that there is an onerous responsibility on the part of the insurer while dealing with an exclusion clause, etc. My lord, then I shall not, my lord, ultimately do it. Then paragraph 23. In such a situation, the doctrine of blue pencil, which strikes off the offending clause being void ab initio, has to be pressed into service. The said clause being repugnant to the main contract and thus destroying it, even without a need for adjudication, certainly has to be eschewed by the court. The very existence of such a clause having been found to be totally illegal and detrimental to the execution of the main contract along with its objective, requires an effacement in the form of declaration of its non-existence, warranting a decision by court. Declaration of its non-existence. Then, my lord, will kindly have a look at, my lord, paragraphs 42 onwards.
Yes.
My lord, please see, my lord, how this clause is being ultimately considered by the court. My lord, please come to paragraph 45 straight away. The analysis starts from paragraph 42.
Yes.
Non-compliance of clauses 3 and 4 of the IRDA regulations 2002, preceded by unilateral inclusion and thereafter followed by the execution of the contract, receiving benefits and repudiation after knowing that it was entered into for abasement, would certainly be an act of unfair trade practice. This view is fortified by the finding that the exclusion clause is an unfair term, going against the very object of the contract, making it otherwise unexecutable from its inception. Now, what I'm trying to do is, my lord, kindly consider it in the context of the facts of our case. You know what the policy is for. You know that the Cold Storage Act and the rules obligate me to pay, my lord, whichever is, my lord, the lower, whichever is the higher. My lord, so far as the farmers are concerned, I have to pay them the market rate.
Higher.
But
And
my lord, so far as
taking the
insurance
lower,
is
lesser,
lower. And even from that lower, you want to take away, my lord, shrinkage.
20%.
Before, my lord, 5 months, you want to take away rottage for which there is no provision. You want to take away excess. Well, the question is, well, then how do I ultimately If the object is, my lord, I should have enough funds in my pocket to satisfy the need of the farmers.
So you are paying the market rate, but you're not getting the market rate. You're getting the lesser amount,
Right.
and with the deduction of 20%.
Even from the lesser amount, they want to deduct.
So that's why even getting the 20%
Now, my
deduction.
lord, how is it, my lord, in line with the object of the main purpose of the contract? And, my lord, this is a statutory, my lord, obligation. I cannot at my will, my lord, depart from it. Now, my lord, here, therefore, the question is, my lord, when your lordship sees the main object rule, and, my lord, applies the blue pencil theory, then the question is whether, my lord, this clause in the contract can survive the court scrutiny. It is unfair from the very inception. Now, my lord, so far as dotted line contracts are concerned, my lord, Brojonath Ganguly versus Central Indian Water Transport Corporation is a parent case. After that, my lord, the law has developed in the case of administrative policies. Now, my lord, we have tried, my lord, from time to time to apply this doctrine to private contracts also without much success. But, my lord, when it is a, my lord, statutory contract, in the sense it is obligated by the statute, entered into by a statutory, my lord, insurance company, and, my lord, ultimately subscribes to the terms laid down by them, then the question will be whether it is a contract of adhesion or a dotted line contract, and, my lord, whether it contains, my lord, seeks to impose unfair terms, my lord, which are against the main purpose of the contract, and, my lord, which are, my lord, otherwise arbitrary. My lord, of course, the doctrine of arbitrariness is considered. Now, my lord, in this context, I will not, my lord, go back to Brojonath Ganguly. This is, my lord, old law. My lord, let me show you, lordship, a more recent judgment on this. My lord, this is reported in 2022. Volume 3 Supreme Court cases, page 655. Well, this is the Jacob Punnen case. Well, there are various facets which are discussed here. I shall not, my lord, trouble your lordship with all those facets. I will straight away request your lordship to please come to paragraph 30. Yes, 34.
Yes.
It would be worthwhile to notice at this stage that one who seeks coverage of a life policy or personal risk, such as accident or health policy, has little choice but to accept the offer of certain standard term contracts, which are termed as contracts d'adhesion, a French legal term. This has been defined as Black's Law Dictionary as adhesion contract, a standard form contract prepared by one party to be signed by the party in a weaker position, usually a consumer, who has little choice about the terms, also termed contract of adhesion, adhesory contract, adhesionary contract, take it or leave it contract, Leonard contract. Some sets of trade and professional forms are extremely one-sided, grossly favoring one interest group against others, and are commonly referred to as contracts of adhesion. From weakness in bargaining position, ignorance or indifference, unfavored parties are willing to enter transactions controlled by these lopsided legal agreements. The Law Commission of India, in its 199th report, has addressed this issue in the report titled Unfair Procedural and Substantive Terms in Contract. The Commission recommended enactment of law to counter such unfair terms, draft legislation. Well, I am not troubling your lordship with the draft legislation. Then 36. The court's remedial power. This is what's important. The court's remedial power to refuse enforcement of such contracts or contractual terms finds support in a few decisions of this court. Recently, while deciding a consumer dispute, this court applied the principle that unfair terms in a contract cannot be enforced if there is absence of free choice on the part of the consumer. In Pioneer Urban Land and Infrastructure Limited versus Govindhan Raghavan, it was held that a term introduced in a standard form contract can be unfair as to constitute an unfair trade practice under the Consumer Protection Act, and observed as follows. This is, my lord, the text of that judgment. A term of a contract will not be final and binding if it is shown that the flat purchasers had no option but to sign on the dotted line on a contract framed by the builder. The contractual terms of the agreement dated such and such are especially one-sided, unfair, and unreasonable. The incorporation of such one-sided clauses in an agreement constitutes an unfair trade practice as per 2(1)(r) of the Consumer Protection Act, since it adopts unfair methods or practices for the purpose of selling flats by the builder. Well, very important. Well, this has ultimately taken this doctrine into the private law field. Even private contracts, have been brought under the fold.
Correct.
Then, 37. Contracts of adhesion, as discussed previously, leave little or no choice to the consumer. In this case, the policyholders were left with no room to bargain and negotiate. In the present case, the standard form contract renewed year after year left the appellants only with the choice of raising the insurance cover. The last renewal,
Of course, result.
yes, of course resulted, that's page 675, of course resulted in the deletion of their son as beneficiary. However, even with this little choice, the result of their being kept in the dark about the new terms which placed limits on individual surgical procedures meant that had any other information with respect to the insurance coverage which could have resulted in higher individual limits for surgical procedures, etc. My lord, this is not important. The principle. Please come, my lord, to the portion, my lord, just under paragraph 37 in the previous page. My lord, this, my lord, ultimately reproduces two things, Brojonath Ganguly and, my lord, unfair trade practice. May I just read paragraph 53 of Brojonath Ganguly? The appellants or any person or authority in the field of insurance owe a public duty to evolve their policies subject to such reasonable, just and fair terms and conditions accessible to all the segments of the society for ensuring the lives of eligible persons. The eligibility conditions must be conformable to the preamble, fundamental rights and directive principles of the Constitution. The term of table 58 is declared to be accessible. Now, my lord, Brojonath Ganguly has, my lord, discussed this aspect of dotted line contract, my lord, very broadly. And then, my lord, your lordship finds unfair trade practice. But I don't want to multiply decisions. What is very important is, my lord, ultimately, my lord, particularly in the field of insurance contracts, my lord, the court has recognized that, my lord, if you find that the contract, my lord, ultimately takes away from the main, a clause in the contract, ultimately militates against the main purpose of the contract, or, my lord, if today a clause is an unfair clause in the context of the main contract, and whether the parties have no individual or independent negotiating power or volition, then, my lord, this, my lord, has to be struck down using the blue pencil rule. My lord, that is, my lord, the basis of my prayer before your lordship. Now, my lord, here, if your lordship will kindly come back to, my lord, to my pleading. What is, my lord, my plaint case? My lord, my plaint case, my lord, your lordship will find at paragraphs 30 to 33. Just three paragraphs.
Yes.
Moreover, the terms of the DOS insurance policy enabling the defendant to deduct 5% each of the gross loss on account of shrinkage and rottage are also unconscionable terms, invalid, contrary to law, and void. Although clearly unconscionable, the plaintiff could not seek deletion of such terms of the said standard form contract, since it did not have any bargaining power, being in a position of take it, leave it, so far as the insurance policy of insurance of the stock at its cold storage was concerned. Defendant should neither have incorporated nor should be permitted the inclusion of and acting upon such adhesionary conditions which are also contrary to law applicable in the field in respect of which the DOS insurance policy was issued. The purpose of the DOS insurance policy is to cover liability of the plaintiff towards hirers or potato bondholders in the event of deterioration, putrefaction, contamination of their stocks loaded in cold storage. The conditions allowing deductibles under the said DOS insurance policy on account of shrinkage and rottage also run contrary to the underlying object and intendment of the contract. Well, the case which I have argued is, my lord, very clearly pleaded. Now, my lord, your lordship knows that there is no, my lord, defense. There is no written statement filed in the proceeding. The proceeding is, my lord, now ex parte. Now, my lord, so far as this is concerned, ultimately.
So they have not filed the written statement.
No. Okay. No written statement. It's undefended. Undefended, my lord. Now, my lord, it is on this basis that I have, my lord, attacked, my lord, clauses 4, 5, and 6, and, my lord, I am, my lord, praying before your lordship, my lord, for allowing prayer C. Prayer C will ultimately directly reflect on my claims, my lord, which have been made at paragraph 58. Since your lordship is on the plaint, please have a look at paragraph 58.
Yes.
Well, your lordship will remember that breakdown, my lord, machinery breakdown policy, they allowed 6,103. My lord, they asked me to sign a, my lord, discharge voucher, and then, my lord, did not go through with it because they knew that as soon as they accept, my lord, my claim on
Then
account.
the total claim is.
Yes. Then, my lord, insurance claim under deterioration of stock potatoes, cold storage policy. My lord, this is what will be impacted, my lord, if, my lord, 4, 5, and 6 remain. Well, I'll just repeat myself very briefly. My lord, 4 is shrinkage. Shrinkage, my lord, is provided for. But, my lord, ultimately, so far as shrinkage is concerned, I shall show you, lordship, what this act says about shrinkage. my lord, it is only, my lord, after 5 months that it applies to potatoes. Here, my lord, we were on the 3rd month.
Within 3 months, 5 months.
My lord, no provision for rottage, no provision for excess. In fact, the policy, my lord, says excess blank. So, my lord, nothing
There's
mentioned.
nothing there.
My lord, rest of the claims, my lord, I shall come back to. My lord, I don't want to trouble your lordship. For that, my lord, I'll have to make separate arguments before your lordship. Now, my lord, this is the basis on which, my lord, I have prayed before your lordship that, my lord, 4, 5, and 6 has to be, my lord, read down, or, my lord, discounted, disregarded, whatever. Now, my lord, please have a look at, my lord, the basis here. I shall just show your lordship. If your lordship will kindly have a look at the Cold Storage Act once. This is the West Bengal Cold Storage Licensing and Regulation Act of 1966. What, my lord, it provides for with regard to, my lord, payment to the farmers, my lord, that is important. I have to show your lordship that.
Yes.
My lord, please straight away come to sections 12, 13 once. Well, let's kindly just see 12.1 is not directly relevant, but may I just read it? Whenever agricultural produce stored in a cold storage deteriorates or shown signs that it is about to deteriorate from the causes beyond the control of the licensee, licensee shall forthwith give notice of the fact to the licensing officer and to the hirer, requiring the hirer to take delivery of the agricultural produce immediately after surrendering the cold storage receipt. Then, my lord, after that, please see 13. For the purpose of subsection 1 of section 12.
Yes.
For the purpose of subsection 1 of section 12, loss of weight or bulk by dryage or shrinkage. Well, no mention of rottage again. Loss of weight or bulk by dryage or shrinkage or gain in weight or bulk by absorption of moisture shall not be deemed to amount to deterioration or showing signs of deterioration, if the loss or gain does not exceed such limits as may be prescribed. If there is any excess in the weight or bulk of agricultural produce stored in a cold storage by absorption of moisture or other causes, the licensee shall not be entitled to such excess. So, my lord, if there is increase, my lord, I am not benefited. Then, my lord, will kindly ignore the rest of it and come to paragraph clause 24, section 24. This is compensation payable.
Yes.
Well, in the event of any loss of or deterioration in any agricultural produce stored in cold storage caused on account of any negligence of the licensee or any defect in the refrigeration machinery, the hirer may, within 30 days from the date of detection of such loss or deterioration by him, apply in writing to the licensing officer for assessing the compensation payable by the licensee on account of such loss or deterioration. Then, my lord, will kindly see, my lord, straight away, my lord, subsection 5. In determining the amount of compensation payable by the licensee, the licensing officer shall take into account the market price of the agricultural produce at the time of detection of loss or deterioration, provided that in case of agricultural produce stored for seed purposes, such amount of compensation shall be 20% higher than that of other agricultural produces. If the compensation of or any portion of it remains unpaid after the date specified in the order passed under subsection 4, the same shall be recoverable as arrear of land rent. So, well, I have to pay, come what may. Now, my lord, what it says essentially is two things. My lord, shrinkage or shrinkage will, my lord, ultimately as per schedule. I've shown your lordship the schedule. And my lord, so far as the payment is concerned, the higher of the, my lord, value, insured value than, my lord, market value, higher I have to pay. In case I do not pay, then, well, it will be recoverable as arrear of land rent. And well, I don't want to trouble your lordship with anything else. Well, so this, my lord, concludes really my argument on, my lord, prayer C. Well, the other arguments are, my lord, on the other, my lord, claims for damages and losses, my lord, which I can do it, my lord, whenever your lordship fixes it next. I think your lordship will be away in circuit for some time. Then, well, whenever your lordship.
That is the problem.
No, I realize. So, whenever your lordship is back, my lord, we can't do anything. Well, I don't want to start on anything new, my lord, because this, my lord, I've completed on this aspect. So, my lord, I just have, my lord, the aspect of, my lord, damages left, which is damages, my lord, that I have suffered because of the failure to, my lord, compensate me for the claims that I have suffered.
So then you have to prove with regard to what is the
My lord, that is a part which I'd like to start, my lord, on whenever your lordship takes name. Parthat to ache, it is parthat.
Census when suffering for the plaintiff, census when suffering for the defendant. Counsel for the plaintiff has argued at length, but due to paucity of time, hearing could not be completed. According case is adjourned. Let the matter appear on. We have 11:30 जून में 24 जून उससे पहले कोई नहीं है तो फिक्स है 24 June
24th June. Very well, great. Kindly just give me.
at
Yes,
11:30.
Time.
11:30.
Yes, my lord, very grateful.
Grateful.
My lord, may I request your lordship to kindly mark this as part heard? Because your lordship has heard this very substantially.
Especially assign matter है क्या?
Assignment.
Commercial है? Commercial.
Oh, very well.
As partner.
Grateful, my lord. Grateful.
As partner. क्या हुआ? हैं? आज 1 PM.
Lord, I appear for the plaintiff. My lord, this is that matter, my lord, where the substitution of the defendant, my lord, partner of the partnership firm, which is the defendant number 1. My lord, I was being led by Mr. Ghosh. My lord, however,
Which one? Item number 13.
yes, my lord, Kunal Finance.
Counsel.
My lord, Mr. Bose, my lord, Mr. Moinak Bose had made submissions on why under Order 30, Rule 4, my lord, the defendant's legal heirs do not become
अच्छा अच्छा
parties
that
to the
partnership.
suit. My lord,
Partnership.
yes, my lord. My lord, in this case, my lord, I would, my lord, have to place, my lord, some provisions, my lord, and my lord, some judgments as well. My lord, Mr. Ghosh is on his way as well, my lord, till then. My lord, if my lord
You will
takes the
continue?
CPC, yes, my lord.
Yes.
My lord, the Code of Civil Procedure, my lord, Order 30, my lord, if my lord takes.
Yes, Order 30 Rule 4 yes pointed out.
My lord, Rule 1 rather, my lord.
Rule 1. Yes, Rule 1.
My lord, Rule 1, Rule 4, my lord, that had to be placed. My lord, if my lord takes
Order 30.
Rule 1, yes.
Yes.
My lord, any 2 or more persons claiming or being liable as partners carrying on business may sue or be sued in the name of the firm, if any, of which partners, such persons were partners at the time of this cause of action accruing. My lord, my lord, my respectful submission, my lord, is that, my lord, a partnership firm, my lord, is not a legal entity of its own. And my lord, is just a compendium, my lord, of the persons carrying on business together. My lord, in such case, my lord, if such partnership firm has a name that can be the name of the defendant or plaintiff in such a case. My lord, however, my lord, according to this provision, my lord, there is no such requirement to make only the partnership firm the partner, the party to the proceeding. My lord, if, my lord, the parties to the partnership firm are known to the defendant at the time, to the plaintiff or defendant at the time, my lord, they may be made parties to the suit as well. My lord, that is what has happened over here. My lord, if my lord takes the plaint, my lord, I have a copy of the plaint. It was not being traceable on the other date, my lord.
Print है? Print आया? Yes.
My lord, if my lord takes paragraph 2 of the plaint, paragraph 2,
Yes.
well, the defendant number 1 is a partnership firm, and the defendant number 2 and 3 have represented to the plaintiff as being partners of the defendant number 1. My lord, at all points in the plaint, my lord, it has been stated that the defendants all the defendants, my lord, jointly and severally, have taken this loan of 50 lakhs from the plaintiff company. My lord, even if my lord takes that yes, my lord. My lord, my lord, the reliefs claimed, my lord, at page 8 of the plaint.
Yes.
My lord, the first one, my lord. Decree for a sum of rupees 1 crore such and such against the defendants and each one of them.
Yes, yes.
And each one of them. My lord, that implies, my lord, that it is not just being sought for against the plaintiff, against the partnership firm, but also against the partners severally. My lord, if I may also place, my lord, the Contract Act, my lord. Lord, section 45 of the Contract Act.
Yes.
Lord, is the devolution of joint rights. Lord, where a person has made a promise or to two or more persons jointly, and unless a contrary intention appears from the contract, a right to claim performance rests as between him and them, with them during their joint lives, and after the death of any of them, with the representative of such deceased person jointly with the survivor or survivors, and after the death of the last survivors, with the representatives of all jointly. My lord, in my submission, my lord, is 45. My lord, is that this section 45 of the Contract Act, my lord, is to be interpreted as an exception to the rule made in Order 30, Rule 4. However, my lord, as Mr. Ghosh had pointed out on the previous day, is that what happens if there is a dissolution of the firm due to such death of anyone or all of the partners, is, my lord, that all the parties, my lord, become jointly liable. My lord, the heirs of the parties become liable as the representatives of the estate of the partners who have, my lord, of the dissolved firm.
But you don't think maybe that is the general law. But unless and until you can prove from the, because these are partnerships.
Yes,
the partnership might be a registered partnership or a deed.
Yes, madam.
So the partnership governed under the deed.
Yes, madam.
Governed by the deeds.
Yes,
if it is governed by the deed, there is a conditions.
Yes, madam.
Correct. So there will be a conditions. If it death, what would be the effect? If it is resigned, what would be effect, and how the shares of the profit and the loss is to be distributed? What would, then how you can prove if today you have not, you being the plaintiff,
Yes,
you file the suit
yes,
against the partnership firm, making the partners as a party to this firm as well as the partner.
Yes,
during the pendency of the suit, one partner died.
Yes,
now they have taken the one partner died, dissolved.
Yes,
correct. But you have not, you filed, and as per your submission, one person died, section 45 and other provisions, the other persons or the legal heirs are entitled, are liable to pay if it has been taken jointly.
Yes, madam.
Then the loan has taken by the defendant jointly, so he is also liable.
Yes.
So, but you have to prove with regard to the contract, what is the condition between you and in the partnership.
My lord, that is the reason, my lord. If, my lord, the partnership deed, my lord, is not,
If
my lord, in
suppose,
my
if
possession.
suppose today,
Yes,
today I allow, today I allow,
yes,
I am not taking care of the submissions and the law which provided by Mr. Bose, no problem.
Yes.
I allow. And you proceed with the matter.
Yes.
How you prove that these legal heirs have got the benefit of this partnership firm after the death of the father?
My lord, I am not saying they are entitled to be made parties to the suit as partners of the.
Not partners, even the legal heirs.
Yes, madam.
So legal heirs. So first you have to prove with regard to the father who is having the share in the partnership.
Yes.
After the death of the father, they got the share in the partnership. They got the profit. That's why they got the profit, and they are entitled for this the 1/3 or 1/4, whatever it is. How you can prove this?
My lord, by way of my lord being the partner.
Yes.
My lord, if my lord, by way of being partner, my lord, upon the death of a partner or upon the dissolution of the firm, my lord, all the partners are entitled to some share of the firm's, my lord, assets and my lord, liabilities. My lord, if my lord, I have made the partner to the of the partnership firm a party to the suit, my lord, upon the death of that, my lord, I can only prove that the estate of the partnership of the partner who is deceased, my lord, has become liable. My lord, after that, my lord, it can only be proved, my lord, after trial, my lord, that to what extent that they have become liable, my lord. However, my lord, that for that, even then, my lord, the estate needs to be heard, my lord.
Okay.
My lord, if, my lord.
My lord, my learned junior has placed the plaint before your lordship. My
Let's
lord,
place the print and you place the 45 of the contractor.
yes, my lord, your lordship has seen the plaint. The case of the plaintiff, my clients, in the suit is very clear. The plaintiff does not simpliciter rely on the name of the firm as the defendant. He has pleaded in every paragraph that apart from the firm, which is a compendium of persons, the partners also jointly and severally made all those promises, issued those checks, undertook that liability. And my lord, the decree also your lordship has seen is joint and several against all, including the partners individually. Now, my lord, I say, and I have argued on the last occasion, that once the plaintiff takes a call and makes a choice of impleading not only the partnership firm, but also its partners, then, my lord, the plaintiff is not taking refuge under Order 30 Rule 1. Because Order 30 Rule 1, I'm not going to repeat, clearly says, gives a choice to a plaintiff who wants to sue a partnership firm, where, my lord, the plaintiff may not know the actual partners or may not know all the partners of a partnership firm. He may deal with only one partner. He may not know the other 7 or 8 partners that are there in the partnership firm. That is why, my lord, the Civil Procedure Code gives a special concession to a plaintiff, either a plaintiff or a defendant who is a partnership firm, that you can sue a partnership firm only by the name of the partnership firm. That option is there with the plaintiff. And in apropos that, Order 30 Rule 4 is casted in Civil Procedure Code, which says if you only implead the partnership firm by name and not the partners, then even if the partners die, you do not have to substitute the legal heirs of the partners in place of the partnership firm. That is why the Order 30 Rule 4 is there. Order 30 Rule 4, my lord, will kindly
that you submitted.
kindly bear with me.
It is not the case only the partnership.
Yes, my lord. And my lord, Order 30, your lordship has also taken a note, I believe, on the last occasion, that Order 30 Rule 4 is a clear departure from Order 22, which says if there are defendants who have died, you have to substitute.
Yes.
It is a departure from Section 45 also of the Contract Act, my learned junior has placed. So, my lord, Order 30's application is limited and restricted only to situations where, my lord, the plaintiff has chosen to sue the partnership firm alone and no others. And, my lord, this I say, not because, my lord, I say it or we say it, this is the view taken by 4
high courts and at least 2 division benches of those high courts, consistent, including our high court division bench. And as early as the 1890, this has been the consistent view. So this is one aspect. I will place those judgments. And the second aspect, which I believe my learned junior was trying to address, your lordship, just before I took over, is that kindly also consider the situation, which I also addressed to your lordship on the last occasion, that what will be the consequence of non-substitution of these legal heirs of the deceased partner. Now, I'll get a decree against the firm and against one of the partners who are on record. I do not substitute the rest of the legal heirs of the other deceased partner. My lord, when I go to execute, but they'll first come and say, my learned friends, Mr. Bose's client will come and say that I am only entitled, I am only liable to the extent of my share in the partnership firm, whatever it may be, 1%, 20%, 90%, rest I am not liable. And the moment I go to my lord, execute it against the legal heirs of the deceased partner, they will say, I was never made a party.
So that's why I put the question on the last occasion also
My
to
lord.
you. You filed a suit against the partnership firm as well as the
partners, my lord.
correct? Claiming the money, and you have specific made out a case that the partnership firm along with the partners have borrowed the amount.
Yes.
So that's why jointly and severally
lord,
liable to
my
pay.
lord.
Unfortunately, one defendant died.
Yes, my lord.
Now you file an application for one of the legal heirs to be added, legal heirs of the one of the partners to be added who passed away. Now you file the case, but you have not disclosed any document with regard to the partnership deed. You have not disclosed.
I do not have.
That's why you have not have. You have not taken any steps also. You have not taken any steps also with regard to ascertain whether what is the condition of your father, what is the situation in the firm of your father. So how you can ascertain, if suppose I allow also, how you can ascertain that?
My lord, kindly appreciates one thing. Partnership is not by status but by contract.
Contract.
So, my lord, contract, there has to be a partnership deed. They are not denying that there is no partnership. Now, my lord, it can be 1%, it can be 50%, it can be 90%. But there is some share belonging to the present legal heirs father. Some share, whether it be 1%, 10%, 50%, 99%. There is some share. Let us assume I don't have the partnership deed. There is some share. Now, these legal heirs, if you substitute, they, and say in the eventuality a decree is passed, ultimately, they will be liable to the extent their father was liable, to the extent their father, whatever, that's for Mr. Bose and those legal heirs to disclose the partnership deed. I am on a question of principle. I am saying whatever may be the share in reality, 2%, 10%, 50%, they will either inherit also the loss and the they will inherit the loss, they will inherit the profit and the liability. So say, for example, I gave a very extreme example, but the extreme of examples has to prove the rule. Kindly visualize a situation. My lord, a partnership has 100 crores of assets. I institute a suit against the partnership and also maybe the partners. My lord, both these partners encounter an accident and die. So, my lord, if I cannot substitute both the legal heirs of both these partners, what will happen is that the partnership firm will have assets of 100 crores, which will be equally distributed or distributed in terms of the partnership deed amongst the heirs. But my claim, say of 100 crores, 5 crores, 7 crores, 50 lakhs, whatever it is, will go unaddressed, although they will enjoy the fruits of the profit of the firm. But that cannot be, with my deepest of respect, be the jurisprudence of, my lord, any civilized country, that you take the profits, but you will not be liable. You take the profits of the estate. My lord, any legal heir will be entitled to the profits of the estate of the deceased partner. But they will take the estate, the profits, but they will not take the liability. They will neither be impleaded, and they will wait for execution stage when they'll come and say, we were not impleaded. So this decree is not binding against me.
Okay.
That cannot be, my lord. The jurisprudence and the case laws exactly say that.
Okay.
It's not what I am saying.
Yes.
Lord, kindly. And this is the personal estate also, not as a partner. judgment gulo bar. Age 18 Calcutta. Lord, may I first cite, my lord? 1890 ILR, volume 18, Calcutta, page 86. Oh, yeah, my lord, sorry. This is a full bench judgment of this court. Lord, kindly see, my lord. My lord, may I read this very short judgment, my lord? May I read? We quite agree with the learned Chief Judge of the Small Causes Court in the opinion expressed by him that it has always been held in Calcutta since Section 45 of the Indian Contract Act came into force that representative of a deceased partner must always be made parties to suits as plaintiffs with the surviving partner or partners. That is the law. Then there are two cases in which that matter has come before this court. One is suit number such and such, Remfrey versus Potit Pabon Sen, in which case the hearing was on the 9th of December 1881, adjourned in order that the plaint might be amended in accordance with the construction of the section. The second, which we may mention, was suit number such and such, Balkishan versus Moni Madhav Sen, the hearing of which was on 5th May 1890, adjourned for a similar purpose, notwithstanding that the case of Govind Prasad versus Chandar Shekhar referred to by the learned Chief Judge was cited. Now, paragraph 3. It is possible that in some other partnership cases, a question might arise as to the applicability of Section 45 and of Section 4 of Succession of Certificate Act. That is to say, the case of a family partnership under Mitakshara law. It is not necessary to express any opinion which would necessarily be more or less speculative as to the effect of statutory law upon such partnership, when we observe that in the present case, it is stated that the learned Chief Judge summary of the evidence that Baldev Das, according in Jagannath, though during his father's lifetime he took a share in the management of the business of the firm, signing in the name of the firm, just as Jagannath and his brothers did, was not actually a partner in the firm at the death of his father. It would appear from this, therefore, that whether the members of the partnership firm were or were not members of Mitakshara family, the firm was carried on as the creature not of birth and relationship but of contract, since had it been family property under the Mitakshara law, Baldev would possibly have been interested upon his birth as a Mitakshara co-sharer in the assets of the family business. This is a different question. Now the last line. The case being relieved of any question of this nature, we answer the reference by saying that the representatives of the deceased Norsingh Das must be appointed under Act 5 of 1818, Act 7 of 1889, and must be made parties to the suit in order that the suit may be properly constituted.
Yes.
So there was a question that he is also a member of the deceased, the legal representative of the deceased partner was Mitakshara. That question apart, clearly the finding of the special bench is that the deceased that the legal representatives of the deceased partner has to be made a party for the suit to be properly constituted.
Yes.
Now, my lord, this has been followed in, my lord, 1918, AIR 1918, Calcutta 160, my lord, again a division bench of the Calcutta High Court.
Yes.
My lord, kindly see, my lord, Justice Chatterjee in his judgment says, my lord, we think that the preliminary objection taken to the hearing of the appeal must prevail. The appeal arises out of a suit to recover money on a hat chitta executed by two persons, namely Upendranath Banerjee and an other as managing partners of the Calcutta Hosiery in favor of Ray Chaudhary and brothers. The suit was instituted, however, by Bidhu Bhushan and several other persons as plaintiffs. In the plaint, as in, my lord, as in the partners. In the plaint, the description of the plaintiff was proprietor and maliks of the firm style Ray Chaudhary brothers. And then the names of the plaintiffs were mentioned. Exactly our case. The name of the partnership firm and then, my lord, the names of the individual partners. The court below gave a decree to the plaintiffs, and in the decree, the names of Bidhu Bhushan and other persons were described as plaintiff without the addition of the word that they were maliks of the firm of Ray Chaudhary brothers. After the appeal had been filed in this court, one of the plaintiffs, Dokkhina Bhanjan, died and the legal representatives were not substituted within the time allowed by law. It appears that an application was made out of time and that a rule was issued to show cause why the substitution should not be made, though out of time. The rule, however, was discharged, the result being that the appeal was dismissed as against one of the plaintiffs, the deceased Dokkhina Bhanjan. 2. Now the decree being in favor of 6 plaintiffs jointly, the appeal cannot proceed in the absence of the legal representatives of one of them. The learned pleader for the defendant appellants referred to Order 30 Rule 4, same rule, which lays down that notwithstanding anything contained in Section 45 of the Contract Act, where 2 or more persons may sue or be sued in the name of the firm, under the foregoing provisions, and any of such person dies, whether before the institution or during the pendency of any suit, it shall not be necessary to join the legal representatives of the deceased as a party to the suit. So this exact argument what Mr. Bose is making has been made. Now 3. It is contended that the suit was really instituted in the name of the firm of Ray Choudhury brothers. Now kindly see, we are unable, however, to take that view. The suit was brought in the names of the particular individuals who were described and plaintiffs and not in the name of the firm. And this is made clear by the decree that was passed in the case. In the case of now Ram Narayan Narsingh Das, this is the exact judgment I cited, in a suit by surviving partners for the recovery of partnership debt which became due during the life of a deceased partner, the representatives of such deceased partner having regard to Section 45 were held to be necessary parties. 4. The title of the suit was Ishwar Das and Jagannath, surviving partners of Narsingh Das, deceased, who carried on business in 99 Cross Street, Calcutta, in the name and style of Narayan Narsingh Das. That appears to be a stronger case than the present. Order 30, Rule 4 does not help the appellants, as the rule applies, this is my lord the law, only to a case where the suit is brought in the name of the firm or against the firm. Kindly read that also. But even if we are to hold that the appeal can proceed in the absence of representatives of the deceased plaintiff, we do not think that there would be any benefit to the appellants, because the representatives of the deceased plaintiff can apply for execution of the entire decree against the defendants, and the decree in their favor cannot be touched by us. Under the circumstances, we think that the appeal must fail and in accordingly dismissed with cause. So, my lord, even the division bench clearly says, the last line on the first page, that, my lord, that appears to be a strong Order 30 Rule 4 does not help the appellant, as the rule applies only to a case where the suit is brought in the name of the firm. Similarly, my lord, if a suit is brought against the name of the firm alone, my lord, Order 30 Rule 4 will not apply.
Okay.
Now, my lord, this is even further, my lord, enunciated. Now, this is Calcutta 2 views I my lord, placed before your lordship. Now, kindly consider the Bombay view. This is, my lord. This is, my lord, AIR 1927 Bombay 581. Again, my lord, a division bench. Paragraph my lord, kindly, my lord, I'm sorry.
Yes.
My lord, kindly, my lord, paragraph 5, I am not placing this Bombay division bench, because, my lord, it just, my lord, quotes the British judgment on which, the English judgment on which, my lord, this decision is, my lord, based. I am not troubling your lordship with that. My lord, kindly come to paragraph 6.
Yes.
Kindly see. It will be seen, therefore, that the ratio decidendi is that you cannot bring a suit against a dead man, and that to make his legal personal representatives liable in his place, you must make them parties in the suit. And although the partnership assets may be got in the suit, this is only because the surviving partner, for certain limited purposes, such as winding up, represent the estate of the deceased partner. Only to that extent Mr. Bose is representing, not to the extent of the deceased partner himself. Now 7. Now I quite recognize that the exact point for decision by us in the present case did not arise in Ellis versus Wadeson. But on the other hand, the judgment there given is of such a nature that it must prima facie be regarded as authoritative in England. The fact that it has not been challenged more for some 27 years, and that it is still regarded in the annual practice as representing the correct procedure up to date, all goes strongly to show that it represents what is now settled law in England. Now kindly come to, my lord, paragraph, my lord, 10.
Just a minute.
I'm sorry.
हमारा अर्धनी को
But kindly, my lord, come to, my lord, this is the law discussed. I don't want to trouble your lordship. Kindly come to page 19. My lord, the page number is indicated at the top left-hand corner.
Yes.
Exactly the decision under order, the discussion on order 30 rule 4. Order 30 rule 3. This is the other judge's view, my lord. Page 19, second paragraph, my lord, the line starts with, in my opinion.
Yes.
In my opinion, the law is the same in India. And rule 3 of order 30 overrides order 21 rule 50, which only applies where there has been no dissolution to the knowledge of the plaintiff. Where there has been a dissolution to the knowledge of the plaintiff by the death of a partner, kindly see, this is what they are saying, that the firm stands dissolved. The legal representatives must, in my judgment, be added as defendants if the separate estate of the deceased partner is sought to be made liable. Clear? Then, in support of his contention that the service of the summons on defendant number 3 and 4 was a good service under proviso to rule 3, Mr. Kania relied upon a passage in the judgment of Shah, Chief Justice Shah, in the case of Jivras versus Bhagwan Das, in which at page 1039 the learned judge said, my lord, I am not, my lord, troubling your lordship with this. Kindly come to again the findings. My lord, next page, page 20, first, second, third paragraph, summing up the matter.
Yes.
Summing the matter up, the proviso to rule 3 in my judgment contemplates service only upon a living person who is sued as a partner in the name of the firm, and does not apply to the case of a partner who is dead to the knowledge of the plaintiff at the time of institution of the suit. In the case of a living partner, by reason of section 43 of the Contract Act, it is not incumbent upon the plaintiff, where the firm has been dissolved to his knowledge, to serve a particular partner when the plaintiff can otherwise effect service upon the firm unless he seeks to render that particular partner liable. Then, but when a partner is dead, this is the case here, to the plaintiff's knowledge at the date of institution of the suit, although again by virtue of section 43 of the Indian Contract Act and by rule 4 of order 30, it is not necessary for the plaintiff to join his legal representative, and the suit is not improperly framed if they are not joined. Yet if the plaintiff seeks to render liable the estate of the deceased partner, he must join the legal representatives as parties. Unless they are joined as parties, the plaintiff will, in my judgment, be unable to reach the estate of the deceased partner, either upon the theory that the deceased partner is included in the name of the firm, and the service upon his personal representative brings them before the court so that they are bound. Under order 21, rule 50. I think that rule 4, kindly consider that, I think that rule 4 was introduced into order 30 to set at rest the doubts which had been felt in regard to section 45 of the Indian Contract Act in relation to suits by firms and for no other purpose. But this clinches the issue. Only order 30 was brought in to clarify the situation where only the firm sues or the firm is sued, not in any other occasion. And my lord, the final finale, absolutely clear, couldn't have been any more clearer. My lord, so two Bombay judgments, my lord, one, my lord, I'm sorry, two Calcutta judgments, one Bombay judgment. Now, my lord, may I show the Allahabad view? This is the most, my lord, succinctly put, AR 1975, Allahabad 207. Paragraph 7. Paragraph 5. My lord, kindly, my lord, considers paragraph 5 to 7, my lord. But kindly see, learned counsel for the respondent at the outset raised a preliminary objection to the maintainability of the appeal. He pointed out that Lala Mohanlal Agarwal, plaintiff number 2 respondent, had died during the pendency of this appeal, and as all his legal heirs were not substituted, the appeal abated as against him. It was urged that the appeal, therefore, was not properly constituted and could not be proceeded with, and that it had abated as a whole. The learned counsel for the appellants did not dispute the fact of the plaintiff number 2 had died during the pendency of this appeal, and no application for bringing on record his legal representative was filed within the period of limitation. He, however, submitted that as a suit was filed, kindly mark this, by a partnership firm, Puran Chand and Sons, the plaintiff number 1 in which the plaintiff number 2 to 6 were partners, it was not necessary to substitute the legal heirs of Mohan Lal deceased in the appeal in view of the provisions of Order 1, Rule 30 of the Civil Procedure Code. So similar case, my lord, just in case of defendants in this case, they were the plaintiffs, the firm along with the partners were the plaintiffs. And this was the point taken. The learned counsel for the respondents, however, submitted that the suit was not only filed by the firm Puram Chand and Sons, but also filed by its partners as plaintiff number 2 to 6. Hence, the provisions of Rule 4 of Order 30 did not apply, and as the decree passed by the appellate court below was to benefit all the plaintiffs and was therefore a joint decree, the appeal has abated in its entirety. Now, my lord, kindly come to paragraph 7. This is really, my lord, the most succinct enunciation of this law on this subject. Rule 1 of Order 30 of the Code of Civil Procedure enables any 2 or more persons claiming or being liable as partners and carrying on business in India to sue or be sued in the name of the firm of any of which such persons were partners at the time of accruing of the cause of act on. It provides new and convenient mode of describing a suit 2 or more persons claiming or being tabled as partners. As partners may adopt this method and bring the suit in the firm name, so also they may be sued in their firm name. A firm, a compendious collective name for the individual members who constitute the firm. When a suit is instituted by or against a firm, it is in reality a suit by or against all the partners of the firm. The firm name stands for all those persons who were its partners at the time of accruing of the cause of action. In other words, the effect of using the name of the firm is to bring all partners before the court. This enabling provision contained in Rule 1 of Order 30 does not, however, do away with the traditional method of bringing a suit by or against the partners individually. The partners may not choose to file the suit in the name of their firm. They may file the suit in their individual names either in conjunction with the firm or without the firm as one of the partners. Such a suit would not be a suit under Rule 1 of Order 30 CPC, inasmuch as under Rule 1, the partners may sue or be sued in the name of their firm. Next, when the partners sue or are sued in the individual names only, and which would be quite legal, the provisions of Rule 1 are not invoked. So also would be the case when the partners sue, this is what I am heavily relying on, sue or are sued in conjunction with their firm. When a suit is filed implementing the firm as well as its partners, the implement of the firm is unnecessary, and the firm as a party is merely a surplusage, inasmuch as the persons whom it stands for are themselves implemented in their individual names as partner. Such a suit cannot be said to have been filed in accordance with Rule 1 of Order 30 of CPC. To such a suit, the applicability of Order 22 is not excluded, which is the normal rule. Rule 4 of Order 30 applies where 2 or more persons sue or are sued in the name of the firm under the provisions of Order 1. In other words, the provisions of Rule 1 would not be attracted if the suit is not filed under Rule 1 of Order 30. Rule 4 dispenses with the requirement of joining as a party to the suit the legal representative of a deceased partner, whether he had died before or institution of the suit or during the pendency, provided that the suit had been filed under Order 1, Rule 30. When 2 or more persons sue or are sued in their individual name as partners, either in conjunction with or without the firm, and of Order 30 CPC is not taken, and to such a suit, Rule 4 of that order would therefore not apply. Hence, where a suit is filed by or against 2 or more persons in their individual names as partner, in conjunction with the firm and without the firm, and any of them dies during the pendency of the suit, it would be necessary to join the legal representatives of the deceased as party to the suit. The entire jurisprudence is clear. And my lord, paragraph 8, my lord, kindly considers, it also contemplates the second argument of mine that if we do not do so, it will pose a serious problem in the execution. I will not read out, your lordship reads it.
Yes.
the bottom of the paragraph 8, it says, my lord, in the absence of legal representatives of the deceased respondent, the appellate court cannot determine anything between the appellant and the legal representatives which may affect the right of the legal representatives under the decree. The effect of abatement of an appeal is the decree between the appellant and the deceased respondent becomes final, and the appellate court cannot in any way modify the decree directly or indirectly. This will create a lot of problems in execution.
Yes.
The jurisprudence is crystal clear. If only the firm is not sued, there is no question of Order 30 Rule 4 being applicable, and there is no question of, my lord, allowing the question of doing away with the practice of substituting the deceased partner. The moment the suit is with the partnership firm name, all the partners or some of the partners, my lord, and one of them dies, we have to, my lord, as plaintiff, my lord, substitute. Otherwise, my lord, we will not be able to proceed against the estate of the deceased partner.
Thank you. So let arrest here.
Yes,
You have to go to the division.
my lord, I understand. My lord, then it is after the vacation, I believe.
Census and appearing for the plaintiff, census and appearing for the division and defendant. Counsel for the plaintiff has argued at length, but due to paucity of time, hearing could not be completed. Let the matter give the date.
Should I keep it or you?
नहीं ये तो उसमें है ना कमर्शियल है ना. Let the matter appear on 12th June under the same heading.
Lordship's leave to mention a matter. In this two matter, Lordship, your Lordship has passed an order on 23rd April and 16th April that the complainant means official liquidator. I am for the official liquidator is directed to take fresh steps for filing requisition for issuance of summons. Lordship, this is a misfeasance matter, but this is a practice that Lordship that we do not issue that.
That's why I find here.
Yes.
See, if in the court has taken the cognizance in the criminal matter,
Yes.
the requisite has to file by the complainant. How the office will take? You file, then the office will issue the.
Yes, Lordship, but inadvertently we missed the order, Lordship. So 1 week time has given. So I am praying for extension of time, or you can, your Lordships can do one thing that your Lordships can, the matter
come
be appear
tomorrow.
to be mentioned in this two matter, Lordship. So that I am grateful, Lordship.
এক্সটেনশন কখন মেনশন করে এখন এট টাইম রাইজ
अपलोड कर दिए.
Today, my lord, I will just show two things in the facts and then take up their judgments to distinguish them.
Just a minute.
Oh, I'm so sorry, my Huh?
Yes.
My lord. So, my lord will now গন্ডগোল হয়ে যাবে. My lord will my lord, only for your lordship, my lord, your lordship yesterday asked me which of the meetings Mr. Motilal were not present. My lord, we have made a chart. If your lordship wants, my lord, I can hand it over with a copy to my learned friend. Now, my lord, two important things, my lord, I would like to show, my lord. My lord, kindly takes, my lord, volume 4, volume 4, 534. আরেকটা কি যেন গোলু কি পয়েন্ট বললো তারা?
Yes. 534.
But first, may I take your lordship to 530? No. 536 ছিল গোলুরটা 535 minute, yes. My lord, kindly see, this is very interesting, my lord. It again came to light yesterday only. My lord. I will kindly first take 534, 11th of February extract. My lord, what fell from your lordship yesterday, my lord, also that trustee may not, there's no resolution, but in the governing council there's a resolution, which is of 11th February. Now, my lord, kindly comes to page 535. This is another extract of the minutes of the meeting, my lord, of 11th February. Now, kindly see the second resolution, page 535, my lord. Resolve further that the composition of the members of the governing council of the society with effect from, my lord, kindly notes, 10th February stands as follows, where again Damani is not there. So, my lord, in the earlier resolution, he is removed on the 11th, but here the resolution says, my lord,
No, you have been removed, also been removed as trustee of the society.
not
with
trustee,
effect-
my lord. Next page is not trustee.
No, page 34.
Yes, 34 is, my lord. First is resolved that Krishna Damani is prejudicial, acting prejudicial in the interest of the society, and is hereby removed and ceases to be a member of the governing council. Well, I'm stopping there.
Yeah.
And the
Second.
next part is, it was also noted
Correct.
that Mr. Damani has been removed as the trustee of the society with effect from 10th. Now I'm showing the next page. Next page is a resolution.
Correct.
The second resolution talks about the composition of the governing council, not the trustee board.
Correct.
It is dated on the 10th February. But according to the earlier page, my lord, on 11th, I was removed from the governing council. Now, which is correct?
Simultaneously. Simultaneously.
My lord, days are supposed to be independent. They cannot be simultaneously, my lord. No, my lord, I am on the point that on 11th, they are saying the resolution was passed. Then how can a resolution be passed on the 11th saying that on 10th, the composition is without Damani? Unless, my lord, Damani is removed, he remains in the governing council. Be it 1 day, 2 days. My lord, the point is, my lord, I don't think there is any resolution at all. These extracts are coming in, no minutes. Yes, my lord, it's just being made and floated, made and floated. Whenever an extract is required, an extract is made and floated. This is a timeline, my lord, kindly appreciates.
Yes, yes, got your point.
My lord, then another very interesting thing, my lord. But again on fact, my lord, on fact. My lord, will kindly see পেজ নাম্বারটা কত ছিল মতিলালের মতিলাল যে চিঠতে লিখলো যে রিমুভ হয়ে গেল তোর পয়েন্টটা 532 তো my lord kindly comes to 532, my lord. My lord has seen in 534 that Krishna Damani is removed as trustee on 10th and as anything from the governing council. Now kindly takes, my lord, 532. My lord, just the paragraph there, my lord, which starts after the list of present governing council members. Please note that the secretary and treasurer of the South Point Education Society was arrested on 8th February for alleged misappropriation of funds. But I am only on, my lord, what Mr. Motilal is saying, that I was the secretary. Now, my lord, kindly appreciates two things. If I am the secretary, my lord, then only, my lord, the provision of removing me as the secretary arises. If I am not the secretary, then obviously the bylaws will not apply. Now, my lord, that means he has admitted
that my appointment as the secretary, which was done on 21st December 2021, 9 December 2021. Malat, vis-a-vis this 9 December 2021, Malat, Mr. Damani, Mr. Motilal, Malat had put in a letter saying that these meetings are not correct because HVL has not been served a notice. The answer was on because of the 16th April 2021. Now, Malat, by this letter, he admits that I was the secretary. If he admits that I was the secretary, then he admits that the meeting held on 9th May 2021 was a proper meeting. 9th December 2021 was a proper meeting. Where, Malat, the notice to HVL was not given because of 16th April 2021. So if he's agreeing to that resolution passed on 9th December 2021, then he accepts also that there was a circular resolution which did not require HVL to be served.
Yes.
Because Malat will kindly see page 42 of GA number 1. I'm just referring to this, Malat. This is the notice of 2nd December 20.
What is the procedure for trustees to be?
Well, I showed it yesterday. Clause 46 and 47,
Correct.
which incorporates the manner in which a member will be
Correct, member. So there is no provision in trustee
Trustee is incorporated, Malat.
incorporated.
So the same provision will come for trustee. Well, 46, 47 says that.
Okay.
Malat, what I'm trying to say is, Malat, if I am not accepted as a secretary,
No, that is different.
so that's why I say that means he also accepts 16th April 2021.
Yes.
And why is that, Malat? Malat, 2nd December, Malat, there was this agenda to take note of the resolution of the trustee passed by circulation on 16th April 2021 at page 42. If he is accepting my appointment on that 9 December, then all resolutions taken on that day, where Malat also Malat taking note of the circular resolution 16th April 2021 was taken, is accepted. And I gave the wrong page number. It's 46, not 42.
GA1.
GA1, page 42.
42.
42 and 46. Trustees এর জন্য এটা হচ্ছে governing council. Yes.
Secretary. Here, secretary was
Sorry. Yes.
Well, at 46 is the governing council meeting notice, and 42 is the trustee notice. Board of Trustees. At page 46, I was appointed as the secretary. That was the to elect office bearers, Malat. Tamani was resolution 4, Malat, page 46.
Yes. What has happened to this 46?
Malat, that's on 9 December, the meeting was held.
Correct.
I became the secretary.
Correct.
Now Malat has seen that letter where he says that he was appointed as secretary. So that means, Malat, he is giving credence to this meeting. Or else he would have said that I'm not the secretary, then these provisions would not apply.
Yes.
Now, Malat, very important, another very important point, Malat. The first objection, Malat, till the time, Malat, Tamani was not being accepted, or Malat, Daga was always accepted as the secretary, Malat. Malat, it came, Malat, only in 2024, Malat, they started taking this point that 16th April 2021 was null and void. Why did they do that? Because, Malat, prior to that, they also gave effect to 16th April 2021. where I am going with this submission, my lord, is null and void is something which cannot be given effect to
Anytime, at any time.
at any point of time. They have given effect to 16th April, but because of the division bench order, they became wiser
From that day.
from that day. So therefore, my lord, it cannot be null and void. First. Then my lord will kindly appreciate Mr. Mitra had made a submission that it is just now that Mr. Lodha has come to know about the, my lord, this 16th April 2021. My lord, may I just show a letter? I'll just show one letter, my lord, and then I'll straight away go into the judgments, my lord. My lord, this is at page 67
Of GA1.
of GA1, my lord. My lord, whatever I'm trying to show is from their application. I'm on their application.
67 of GA1 of 21. CS21.
CS21.
Yes.
My lord, kindly sees, my lord. This is a letter sent by the lawyers of Mr. Lodha.
67.
66, my lord.
66.
My lord, kindly sees from Fox and Mandal, my lord.
GA1.
My lord has got GA1. TS21, my lord, page 66.
Correct.
It's an email, my lord.
Yeah.
My lord, kindly sees from.
Yes.
It is from Fox and Mandal.
Debajan Mandi, yes.
Now, my lord, kindly sees our client just of the subject, my lord. Who's he writing for? This is Mr. Lodha.
Issued to Mr.
No. On behalf of Mr. Lodha.
Lodha.
Now, my lord, kindly sees the date. 13th April 2022.
Correct.
Now, my lord, kindly sees page 67.
Yes.
Kindly sees, my lord, from annex, my lord, just the third paragraph at page 67.
Yes.
The second paragraph, my lord.
Our client never received any notices.
From my lord, our client has never received any notice in connection with the alleged circular resolution of 16th April 2021.
Yes.
So he comes to know that there is something. He's saying, I've never received the notice.
Yes.
Then kindly sees, my lord, from annexure 2, the next paragraph.
Yes.
To the purported notice dated 2nd December 2021 enclosed to the email dated 9 December 2021 of Mr. Motilal, our client for the first time came to learn that the joint administrative penalty appointed over the estate of such and such, requested for appointment of such and such, has also been addressed by APL committee. This is also referred to a decision taken by the APL meeting of it now writes the entire thing, knowing about 16th April. Now, my lord, kindly see annexure 2 to the notice of 2nd December. Page 42 I had shown your lordship. Page 42, your lordship will find annexure 2.
Meeting of the trustees notice.
No, my lord, that is 46. Now 42, my lord.
42. Trustees.
Trustees, my lord. To take note of the resolution of the trustee passed by circulation on 16th April 2021, annexure 2.
Correct.
So he came to learn about annexure 2 in 2022 minimum from Mr. Mandal's letter. So to say that I was never aware of this, it never came into my hand, my lord. That, with humility, I say, my lord, is not a correct statement.
Okay.
It is not a correct statement.
Contradictory.
My lord, contradictory, I would say it's not correct. But I could have used some other words, but my lord, someone who has said this, my lord, is, my lord, I cannot say any other words, my lord.
Yes, yes.
So, my lord, I just wanted to point out, my lord, the fallacy in the argument that 16th April is still open. And as if, yes, we can challenge it. But since it's in a collateral, therefore, we are saying all these things. My lord, it's the other way around.
But this page 66.
66, my lord, yes, my lord.
Which you now
yes, my lord.
Pointed out.
Yes, my lord.
That is from the this Fox and Mandal.
Yes, my lord.
Correct.
Representing himself. Representing whom?
Harshvardhan
Lodha.
Lodha. But in whose letterpad?
Letterpad.
Letterhead?
But I think, my lord, this is their document, my lord. I think this is when they prepare it, my lord, for my lord, making copies. I think it comes like this, my lord, for some reason. I think so, my lord. I don't know. They will explain. Vishwajit Motilal, I don't know, my lord.
Correct. That
But I don't know. I don't think it's a letterhead, my lord. Can I share my letterhead? Okay, my lord, because I'm also not too good with this computer thing. He's saying that, my learned friends are saying, Outlook print. This has been downloaded from Mr. Vishwajit Motilal's email. Therefore, this is coming like this. But my lord, he also had a copy of this letter. He's marked. He's also marked, my lord.
Copy
In
two.
copy 2, my lord, he's there.
Page
So it
75.
has come from him, my lord.
Page 7.
That's
why
which is, my lord.
that's why
No, my lord.
Court is
obviously,
confused
yes, my lord.
because 75 copied to Harshavardhan and copied to Biswajit
Yes, my lord. That as a lawyer, he's doing it.
Matilal. Correct. And other thing. But that's why I'm finding in the first page it is the letterhead of the Matilal.
It's not letterhead, my
How
lord.
he is sending his own letter to himself.
But it is not his letterhead, my lord. My lord, it gets very difficult. I understand that, my lord. When people come to us for matters, my lord, then we tell them, give us the entire correspondences. Then, my lord, it becomes a complete maze because it first from bottom to up. Then, my lord, there are so many forwardings, you wouldn't know who's sending mails to whom. So it becomes a maze, my lord. That's true.
Yes.
But this is absolutely, I cannot join. It's absolutely right. This is what happens.
Okay.
So, my lord, this is the point which I was trying to make out. Now, my lord, kindly takes the application GA1, my lord. And yes, my lord, another, my lord, kindly sees para 11. I'm taking your lordship to the application, my lord. Kindly comes to the application GA1, my lord.
Yes.
My lord, kindly takes paragraph 11, my lord. My lord, I had been trying to show your lordship certain instances, my lord, where your lordship will find that for no reason, my lord, for some reason there's a tweak in the facts. Very simple tweaks, but tweaks which matter. And here, my lord, your lordship will kindly see page 11, para 11, my lord.
Because you are the public prosecutor.
No, I'm the government pleader.
Government pleader. But you are doing the public prosecutor work. That's why you are tracing out all these things.
My lord, because, my lord, I believe, my lord, when your lordship also, my lord, I feel in that you come to court with clean hands. That is why, my lord, I'm taking these points, my lord. But 11, from the documents referred to in the previous paragraph, it will be evident that the respondent number 6, as well as the Secretary Vishwajit Motilal, were being excluded from the affairs of the plaintiff. My lord, pauses here for a moment. Your lordship has been given a chart of letters continuously being issued to Vishwajit Motilal asking him to be present in the meetings. This is a completely false statement again made by Vishwajit Motilal.
From the document in the previous paragraph, it is evident that the respondent number 6 is
বললাম না এসে আমাদের মিটিং এ দাঁড়াও Page 57 is one of such letters asking him to join the meeting, Malad.
Okay.
So, Malad, if he's at a meeting of the governing council or the trustee, Malad, I'm sure he wouldn't be in a position to say that I'm being excluded from the affairs of the plaintiff.
Yes.
And the paragraph is written in such a manner as if the secretary himself is being excluded from the meetings of the plaintiff, but that is not so, Malad. He admittedly was not the secretary at that point of time, Malad.
Yes.
To my knowledge, derived from records.
Yes.
Yes.
And he Malad, very cleverly, Malad, the affirmation is this is derived from records.
Page 27.
Affirmation is those contained paragraph 11 are based on information derived from the records of the case. He wouldn't say it's true to his knowledge. Matlab, then matlab, things would have been difficult.
But 9 ta to aaj 921 true to my knowledge.
9 and 21 I had already pointed out. He was feigning as if he's the plaintiff, but he's not the plaintiff. Those matlab.
That already recorded.
And again, that effect. I thought someone pushed me. But this time it was my junior. But I'm really very getting scared of this. Someone pushed me from the back.
It is better the pushing you, not
pulling. So, Malat, these are the basic facts which I wanted to point out as Mr. Damani, Malat. Because Malat kindly appreciates bad percolates in everyone. Malat, bad percolates in everyone. Some gets noticed, some doesn't get noticed. Therefore, the question of conviction always remains. And that has been imbibed into the regulation of this trust. Yes. So to say that I am bad, you can't just throw me out like that. For once I have been able to come before your lordship and say certain things, Malat. I appreciate that there are cases against me. But this is also something which I, as a matter of right, I can say before your lordship. Now, Malat, kind... Huh? No.
Yes, next.
Malat kindly takes the pleadings of GA number 1. Malat will see till paragraph 51. Malat, obviously the plaint case is reiterated. Then Malat kindly takes 52. As would be evident from what has been stated here in above, respondent numbers 1 to 5 are invading and or threatening to invade the valuable rights of the petitioner society, its management, its assets and company. Invasion is such that compensation money shall not afford adequate relief. Malat, it does not say that it will tantamount to a multiplicity of judicial proceedings, therefore they are not entitled to an injunction. That's the basic requirement. They don't make out that case. So, Malat, they are not entitled to any injunction. Then Malat kindly sees there is extreme urgency in the matter in view of the fact that the respondent numbers 1 to 5 are attempting to take unlawful control of the management and affairs of the petitioner society, which includes the schools. Now, Malat, they are talking about the schools. That is South Point and South Point High School. They are seeking to forcibly oust the bona fide and valid trustees and governing council members of the petitioner, including the respondent number 6, as well as the newly appointed trustees and governing council members for the management and control of the petitioner society. The respondent numbers 1 to 5 are attempting to take over management and affairs of the petitioner without any authority, is misusing the purported 53. True to his knowledge. And is misusing the purported proposed circular resolution by causing the same to be circulated to persons who have no locus or authority to be involved with the petitioner society, including the person who are wrongfully and fraudulently holding themselves out as trustees and members of the governing council. In view thereof, urgent interim release has prayed for. The present application are required to be passed, as otherwise this is every argument prior. Well, two things from here. It appears that the society is trying to challenge its own resolution of 16th April. Well, that is something which is unheard of.
Yes.
Basically, my lord, this has been affirmed. 28th of February 2024. Now, obviously, my lord, concerned about Mr. Lodha not being in a position to challenge himself, they are trying to take the plaintiff
from the
through which this is trying to be made out. Main prayer, main prayer, 16th April. My lord, as far as I understand, my lord, the relief in the plaint, my lord, at paragraph 51, your lordship will find nothing to do with my lord, the 16th April, my lord, 2021 resolution. But the case which they are making out, my lord, is with regard to that resolution in the interim application.
Page paragraph 51, page 21.
Paragraph 51, your lordship will find the plaint prayers.
Correct.
And in 55, my lord, as I said,
first prayer is with regard to the declaration that with regard to paragraph 6, the trustees. trustees of the society.
That's a declaration they want.
That's a declaration.
Declaration.
Correct.
But what are they saying here, my lord, in the, my lord, 53, my lord, they are saying because of that circular resolution.
Proposed circular resolution.
Proposed circular resolution.
That's the 22nd of February.
So, my lord, therefore, they are trying to espouse the cause of Mr. Lodha through the society itself.
It's good, yes.
That is what is the point. Now, my lord, they have asked for receiver. Stroke. Special officer. And the pleading, my lord, will kindly see at para 56. 55, sorry. In order to ensure that the trustees and members of the governing council, whose particulars have been given in paragraph 6 and 7 hereof, discharge their function without any form of interference or intermeddling, it is necessary that a fit and proper person be appointed. Not just and convenient, my lord, so they fail the test there itself. Order 40 is very clear. It has to be just and convenient to appoint a receiver. There is no pleading of any just and convenient, just says that necessary that a fit and proper person be appointed. Then, to ensure that the resolutions passed by the trustees and the members of the governing council whose names are appearing in paragraph 6 are given full effect to. Well, it kindly now sees the prayer in the plaint.
Page 21.
21. Now, my lord, this is basically asking the receiver by the first requirement of the receiver's prayer in para 55, my lord, to ensure resolutions passed by trustees and members of the governing council names appear in para 6 are given full effect to.
Correct.
So, my lord, this becomes a mandatory injunction. It's a mandatory injunction. Pending what your lordship will kindly see that a declaration. Without a declaration, my lord, can this final relief be granted in the form of a receiver? That is the question. This is in the nature of a mandatory provision, well, it's an execution basically.
Correct.
Then, my lord, kindly see press C. It's a perpetual injunction from interfering and intermeddling in the management. In the main press, my lord, suit.
Correct.
And my lord sees 2. To ensure that there is no interference or intermeddling by the respondent numbers 1 to 5. Without a declaration, my lord, which they have asked for.
Yes.
Can they get this final relief through a receiver? And my lord also sees the wordings.
Yes.
They are saying it just gives me 1 minute, my lord. I just missed the place where I was trying to find that out. New trustees will have to hold. Yes. 53, my lord. They say that newly appointed trustees and governing council members should be given the right to do the needful. My lord, it is standard, my lord, test that if a person cannot show that the whoever is running the show has done something wrong, or the management is not working, the schools are not functioning, then only the consideration of changing that status quo comes through a receiver. And very important, my lord, here they are not asking for a receiver to run.
They may be allowed to
execute.
So now at present, who is running that?
Well, there's the principal, the headmaster, whoever there are.
There's no committee.
Well, the governing committee is there.
Who are they?
Well, it depends, my lord. Now that is the point, my lord. That is why they need the declaration.
That's why I'm telling, because they need.
They have.
So as per their prayer, they are not. At present, they are not in the management.
Yeah.
Correct. As per their
Yeah, my lord. I have a suit, my lord. Officiating secretary.
They are asking a relief from the court.
Relief from the court, because it was
Interim
a
order.
substitution.
They are
of
interim
the
order.
management which is running.
So who is at present?
We are running. CS 16 is there, my lord. And the managing committee is otherwise there. The governing council is over them.
Correct.
It is there. That is the point. And my lord, the managing committee has also another father to look after them. That is the CBSC, क्या बोला? The CBSC council guidelines also.
That is different.
That is a different. But otherwise, my lord, I have filed a suit, my lord. Filed a suit. And that's why, my lord, they're asking for a declaration, my lord. No one asks for a declaration if he knows that his legal character, he has a legal character.
So as per this prayer, if it is read with the main prayer of the plaintiff, so they want the legalization of their resolution.
Yes. Final relief.
Final relief. That is your submission.
My submission, my lord.
Okay.
My lord, whether this can be given, is this an interim prayer? But I have even shown the language, my lord, it's the same as the final relief, my lord. And my lord, there is not a single instance shown that the schools are not running properly. Not a single out of any kind of pleading that this is happening, that is happening, they are fighting, schools are not being run. Nothing of that sort.
Yes.
So it is admitted that they are not running, someone is running, and it is properly being run. This is the point, my lord. And what do they intend to do? The smooth running they want to prevent without getting a decree.
Correct.
That is what they are trying to do. Now, my lord, the judgments which my learned friends have relied upon and which, my lord, I have to distinguish, my lord, because I don't think Mr. Mukherjee has dealt with these, my lord. My lord, kindly sees the compilation given by Mr. Bachawat while he was arguing, I believe. এটা করতে গেছিল ও আমরা বানিয়েছি sorry আমরা বানিয়েছি sorry but I'll give the citation separately, my lord. I'm sorry, my lord. My lord, I have had a compilation made, but your lordship is not having the compilation separately given, my lord. But the first judgment is Reverend Paritosh Canning and another versus Anil Rajkumar Mukherjee.
Of yours?
The Supreme Court
My
judgment.
lord, this is no theirs, my lord.
The
They have
plaintiff,
not given a compilation. I've been told.
Honorable Justice I.P. Mukherjee and Honorable Justice Nizamuddin's judgment.
But it appears that single judgments, when individual judgments have been handed over. But so your lord, hey, আমাদের কাছে copy আছে? And there are three judgments, my lord. One is Anil Rajkumar Mukherjee versus Reverend Paritosh Canning by the Lamatinia matter, my lord. The division bench and then the Supreme Court. Another is Charu Kishore Mehta versus Lilavati Kirtilal Mehta, Supreme Court.
relied by the plaintiffs.
Plaintiffs.
I.P. Mukherjee judgment है paragraph 2 ये लिखा है
And George Sharna film করতে দেব।
Yes, citation.
Well, this is 2019 SCC Online Calcutta 1944.
Calcutta.
Well, Justice I.P. Mukherjee. Well, in the Lamatinia matter. Well,
Acha, that one.
That one, and then the order of the Supreme Court from that judgment. Well, compilation নেই তোর কাছে?
না না ওটা দেখা
এটা কি করে দেখো? কিন্তু এটা তো দেখালে তো জজ মার্ক করবে কোথায়? He has to mark somewhere, no? If he wants to mark.
maybe assist your
Well, maybe assist your lordship, my lord. Would your lordship like us to find them up?
a lot of judgments shown.
My lord, they've shown 14 judgments. ফিজ আজকে আমার কি যাবে তার ফিজ আমার ঠিকভাবে আমরা দেখছি
ये और कोई जजमेंट है क्या? देखो 19 SCC.
Calcutta 1944. এটা থেকে এটা বের করুন, এটা দেখি, এটা হবে বোধহয় না? কোনটা? না।
Yes, 2019.
And here, in Justice Mukherjee's judgment, my lord, paragraph 2, your lordship will be finding that a very harsh interim order had already been passed. By the interim order of this court directed that the boards of governors of the schools in question of La Martinia school will not take any decision regarding management of the school till the disposal of the application. In that period, the ex officio governors will not appoint any person as additional governor. By the same order, this court reached leave to institute the suit granted earlier under section 92. After considering these, my lord, your lordship will kindly come to 11. Considering the fact that there is a substantial question to be tried and also taking into account the prima facie case and the balance of convenience, we appoint Mr. such and such, the former student of such and such, the school as the administrator. So it's an individual person for administration where, my lord, the school was suffering.
Correct.
Here there is no allegation that the school is suffering. Just by making a simple bold allegation, my lord, that is not proper. To change the nature and the running, my lord, they have to show that there is some malafide or prejudicial thing happening to the school. That is not there with your lordship. 13, your lordship will kindly also see. Now, next judgment is, my lord, it's not the judgment, it's an order upholding this, my lord, by the Supreme Court. My lord, it is not reported, my lord. But if your lordship once I can read it out, it's a very small order, my lord. If your lordship wants.
That portion is set aside.
Yes.
Administrator portion is set aside. Other remaining was there. I
No,
think
my lord,
so.
no. My lord, my lord, may I say, after hearing learned counsel, learned senior counsel petitioners on instances of the appeal preferred by the petitioners, division bench against the order of learned single judge, it shall be treated as withdrawn. We accept the request. Appeal of the petitioners before the division is thus dismissed as withdrawn, and consequently any interim management made thereof shall stand resolved. So, my lord, I don't know why this is not a judgment of the Supreme Court, my lord. So, my lord, I don't think it will have any bearing as a precedent, my lord. With humility, I say, my lord.
Correct.
Then, my lord, the judgment which they have referred to, which I need to distinguish, is, my lord, this is 2007.
ए मनोतोष इसको पिन कर दो दोनों के
এটা একটু বের করে দিন, এটা বের করে দাও থেকে।
इसको
এটা
पिन कर
ছোট।
Yes, next one.
This is, my lord, Charu Kishore Mehta, 2007, 12 Supreme Court cases, 561.
Yes. Yes.
My lord, will kindly see. There was obviously, my lord, infights going on. Para 7.
Yes.
After hearing the arguments on both sides, we find that there are serious disputes in the parties which ultimately will cause serious difficulties in the running of the hospital is under management of the trust. In view of the present circumstances, the temporary measure will direct such and such and such and such in the hospital shall be in charge of the hospital for the day-to-day running of the hospital and research institute. These two administrators will take all decisions relating to the administration of the hospital. They shall give a report to the Board of Trustees every 2 weeks. Any direction by the Board of Trustees that we should are to be issued to these two administrators only in the form of resolutions and not individual instructions by any trustees. So the trust remained. Now the question is which trust?
That is
they are asking for a declaration. I have a trustee board which is functioning. Till they get a declaration, my lord, how can they get these orders? And the simple thing is, my lord, for an interim prayer, the main thing is for a privacy case, which basically requires, my lord, some inputs that there is some violation, some intrusion, something happening for which this should be given. CPC.
Yes, next.
But may I just for once, my lord, I'll be very quick, my lord. My lord, only one thing, my lord. My lord, order 40, my lord. order 40 clearly mandates, my lord. My lord, may I just read, my lord, kindly, my lord. Where it appears to the court to be just and convenient. That is the test, my lord. There is no such pleading, my lord. And what is just and convenient? That is most important. My lord, may I just refer to a judgment, Madras, my lord, though not the Supreme Court, it is a judgment of the Madras High Court, my lord. It is AIR 1955 Madras 430, my lord. দেখি দেবো তাড়াতাড়ি কর, জজ সাহেবের তারা আছে, অন্য ম্যাটার আছে, তাড়াতাড়ি কর। আননি পেয়েছো তাও এরকম করছো কেন? দিচ্ছি দিচ্ছি বাবা। কজন কটা? সবাই আলাদা হয়ে গেছে? সবাই এখন আলাদা হয়ে গেছে। দিচ্ছি, আমি একটু পড়ে নি তো দিচ্ছি। কোথায় গেল? 5 পয়েন্টটা কোথায় গেল?
Yes, with paragraph.
Yes. Now, my lord, kindly sees, my lord, this is 1955 Madras 430. My lord, kindly comes to
17.
17. My lord, 17 is the basic one. My lord, your lordship is all aware, my lord, but what can I say, my lord? My lord, that is the requirement of just and convenient. What is just and convenient? My lord, it has been given. Appointment of receiver pending us to the matter resting in the discretion of the court is not arbitrary or absolute. It is sound and judicial discretion taking into account all the circumstances of the case, exercised for the purpose of permitting the ends of justice, protecting the rights of all parties, interest of the controversy and subject matter, and based upon the facts, there is no other adequate remedy or means to accomplish the desired objects. The court should not appoint a receiver except upon proof by the plaintiff that prima facie he has a very excellent chance of succeeding in the suit. 3, not only must the plaintiff show a case of adverse and conflicting claims to his property, but show that some emergency or danger or loss demanding immediate action under his own right, he must be reasonably clear and free from doubt. The element of danger is an important consideration. Court will not act on possible danger only. That is their pleading, my lord. The danger must be great and imminent, demanding immediate relief. Then 4, an order appointing a receiver will not be made where it has the effect of depriving a defendant of a de facto possession, since that might cause irreparable wrong. My lord, I also rely on this, my lord. They are saying put them into power, then there must be someone in power. That is me.
Usurpation of control.
You are trying to usurp the control. That is not allowed. And my lord, 5 is what I was hinting at continuously, my lord. Conduct. The court on the application of a receiver looks to the conduct of the party who makes the application and will usually refuse to interfere unless his conduct has been free from blame. He must come to court with clean hands and should not have disentangled himself in the equitable relief by laches, delay, and acquiescence, etc.
Yes.
So, my lord,
আরেকটা আছে যেটা
কোনটা?
ওই
বিবেক বিবেকটা তো বিকাশ তো next, my lord, this is and 1 is good enough.
Not relying upon.
No, I don't think so, my lord. Not required, my lord. But this doesn't give the principle. It only decides, my lord, what is. So I've handed over a copy to my learned friends. They want, if they can show, my lord. If they want to distinguish on themselves, my lord. Then আর কিছু আছে? My lord, unreported.
Resolution is an agreement.
My lord, this, my lord.
আচ্ছা এইটা একটুখানি দেখিয়ে দাও তার রেজলিউশন ইজ টপিকে ঢোকার আগে। হ্যাঁ, এখানে বলছে Vishwajit Motilal বলছি from perusal of the subject notices I found that the purported circular resolution of the society was allegedly passed on 16th April 2021. So they accept that this resolution.
This, my lord, is an unreported judgment.
It's not in the SCC. SCC online?
No, my lord, this I didn't find in the SC online. কি বলেছে? Edit by? My lord, at present, my lord, the committee or other trustees is headed by Justice Javedi in my lord, on the governing council. my lord.
President.
So I was just trying to find out who is the
Correct.
person. Justice Javedi, my lord.
20.
Now, my lord, kindly takes paragraph 20 here, my lord. I had made a submission, my lord, that the resolutions of the society would be in the nature of an agreement between the members. And if it's an agreement between the members, it cannot be something which can be said to be null and void ab initio. Because, my lord, then it is something which will become bad for all members to come.
Naturally.
But here, there is only one person who's saying that it is null and void ab initio. So I am saying an agreement will not be null and void ab initio, but will be voidable because it will not fall under the provisions of section 27 of the Contract Act. Where 27 is the only point where it is null and void, my lord, or else it is a declaration.
Correct.
So that is why I am submitting, my lord, that a resolution is an agreement. You cannot say it is null and void and does not require any declaration or to be challenged in any court of law. But I will kindly see paragraph 20 at page 29. The South India artist, my lord, kindly see paragraph 20 once, my lord. And there's a discussion, quite a few cases shown. Then the above judgments make it clear that the bylaws of the cooperative society constitutes a contract between a society representing by its managing board body and its constituent. If the bylaws are in the nature of contract, the resolutions by the committee may have the same character. If that is the case, my lord, the resolution of 16th April 2021 is in the nature of an agreement. If it's an agreement which is being suffered by one of my learned friend's clients, my lord, he has to challenge it, declare it as null and void, or deliver up and cancelled, whatever it is, but not in a collateral, my lord, proceeding saying that it's null and void. And where I've shown that was given effect to, my lord, kindly appreciate, still this division bench, my lord, there was no intrusion. So if it has been given effect to, then how can it be null and void? Good, bad, indifferent, my lord, the APL committee had instructed whatever it is. My lord, when it becomes a resolution, it's a
If a resolution is challenged,
my lord,
before the passing of the final order, some act has been done in terms of the resolution, and subsequently the resolution is set aside or declared null and void by the court of law.
Cannot be given retrospective effect like that, my lord.
What would happen to the act done by the?
That will be binding for all third parties to come.
Yes.
Unless court gives some kind of prospective overruling or something of that sort. But that is why I'm saying, my lord, the conduct is showing that it has been given effect to. 2022, they came to know, they did not challenge.
Correct.
That is why I'm saying it cannot be said to be null and void. And today, my lord, no one is there to challenge it. At least he cannot challenge it.
Okay.
It will be barred by limitation, which Mr. Mukherjee has already argued. I'm not going to argue. Yes. Okay, suppression, clean hands, my lord. I'll just show one judgment. 1994, 1 SCC. null and void আর irregularity এখানে জাজমেন্ট দেখালাম তোমাদেরকে বললাম বের করতে এটা কি কোন প্যারাগ্রাফ বললাম
Should be mentioned.
মানে এটা ইন্টারেস্টিং রিড মালেট মানে kindly takes this 1994 4 SCC 422 malat here malat the Supreme Court was dealing with the distinction between what is a nullity and what is an irregularity. Irregular, then it needs a declaration. Malat para 13, para 16 malat. The test has been, as to when violation of a mandatory provision makes an order a nullity, has been the subject matter of various decisions of the court as well as courts beyond the 7 seas. There has to be a violation of a mandatory provision. These are their views of reputed text writers. Let us start from our own. I'm not reading all those things. It was held that even if a notice is not required, kindly says it was held that even if a notice under Section 80 be defective, the same would not be per se render the suit requiring issuance of such a notice as a precondition for instituting the same as bad in the eye of law. As such, a defect can be waived. So what the test is, if whatever the instrument is, if it can be waived, then it will be an irregularity, not a nullity. If it cannot be waived, mandatory, therefore it is null and void. Let us consider the surplus resolution. Good, bad, indifferent. Could or can Mr. Lodha waive it or not? He can. I'm not asking him to waive it, but obviously he can. And he has to a certain extent till the time that the division bench has been passed. So, it is not a nullity. Maximum, it can be an irregularity. And lastly, 1994 1 SCC is very well known. A person coming with unclean hands is not entitled to any equitable relief. 94 1 SCC, page 1, fraud and
non-production, non-mention.
fraud. Collateral can even consider collateral opportunity. Whatever. Paragraph 6 kindly see.
Yes.
The fact of the present case leaves no matter of doubt. Para 6 The Jagannath obtained the preliminary decree from the court. A fraud is an act of deliberate deception with the design of securing something by taking unfair advantage. And then kindly comes at placetum G and H at the bottom. A litigant who approaches the court is bound to produce all the documents issued by him which are relevant to the litigation. If he withholds vital documents, then he is not entitled to any order.
Yes.
Unclean hands.
Unclean hands.
That's all.
Yes, my lord. Those are my submissions, my lord. My lord, my lord, this judgment, my lord, is what I wanted to show, not that one. 2012 SCC 133, my lord.
44 to 47.
44 to 47. Now, that is what unclean hands, my lord. I'm giving you some good literature to read.
Page 4, para 40.
44 to 47.
44 to 47, my lord. Well, those are my submissions, my lord. আমার পড়বো তোরা পড়ে নে those are my submissions.
That's
3
all.
o'clock, my lord. We have been between on time. Very grateful, my lord.
Thank you.
Anyone else from your side or your side?
No.
Okay.
So now defendants close.
They finished 1 day short, which is good. They had 1 more day. But would your lordship keep a day for me to start
And
my reply?
tomorrow it will not be taken because tomorrow is a company matter.
I see.
And day after tomorrow it already fixed.
কবে আছে fixed আছে?
Till 8 it is, but tomorrow I will not take because tomorrow is the company matter. 8 can come.
But 8th of which day?
It's
But don't keep it on
fixed,
Thursday.
It's
Don't
fixed,
keep
my
it
lord,
on
tomorrow,
Thursday.
day after as well, my lord.
They
But
finish
that's why
early.
tomorrow my company matter.
But day after I'll have a little problem. I'll be
Day after you will not be available.
any other day, not gives me
Then it will go to when?
next week, any day, not whatever day suits your lordship. Oh, that's why he's also smiling. I see. I see. Your lordship is going to Jalpaiguri. I'm not going to stay after 2. No point.
वो रिकॉर्ड कर लेना नाम सब है सुनसो कर लेना. Counsel for the defendant number 3 has concluded his argument. Full stop. Due to paucity of time, the counsel for the plaintiffs could not argue the matter. Give reply to the argument made by the defendants.
No point.
According.
Good.
It is found that the matter is fixed tomorrow and day after tomorrow. That is 7th of May 2025, 8th of May 2025. But this court will not take. It is not possible for this court to take the matter on 7th May, as the company matters are fixed for hearing. As regard 8th of May, the learned counsel appearing for the plaintiff is having some difficulties. Accordingly, hearing of this case on 7th and 8th of May 2025 is adjourned. Let the matter appear on 10th June or
What time does it open?
10th June and 12th June at 3 p.m.
Instead of 10th, can it be 12th?
10th and 12th.
But can it be 12th instead of 10th and instead of 10th, 12th and any other day?
12th कोई दूसरा date है 12th and 17th June
Oblige.
3 p.m. No? Yes.
But I appear for the plaintiff in the suit. Now there are 3 applications which is pending before your lordship, which is the GA1, which is my injunction application. I'm enjoying a order of injunction at interim stage, is continuing. GA2 is my learned friend's application for vacating the order of injunction on the ground of non-service, non-compliance of 3A, immediately not served, whatever. And GA3 is section 10. Stay. There are city civil court prior suit. This is that matter with regard to a restaurant in off Park Street, the Tiswas Kitchen. Now, I think what I understand, Mala, today they have filed an amendment application sometimes back before the city civil court. Whatever, and affidavits are complete over there. It's still not being heard because they have not taken any steps to get it heard, whatever.
No.
Now, in my application, Lordship has passed an order of some payment in GA4. Recall that ad hoc payment, not paid. They have only paid for 1 month, which is in the month of no area has been paid. Month of March has been paid. 50,000 for the month of March has been paid. Thereafter, no further payments. No appeal. Even the areas were supposed to be paid before May. So 31st April was the last day. No area was paid. Now, and they enjoying the property, running business. Now they are not allowing me to move my injunction application, showing me the section 10 in city civil court, judge, whatever. It's all in a statement and they're enjoying my property. This is a unique way of accepting an order, also not complying with the order and then enjoying the property. And today they are not moving the application.
Yes.
Senior is on the way.
Where is Mr. Tariq? Coming?
Yes.
What is your instruction? You will proceed, Minmat? What is the instruction?
Actually, the city court matter has been not heard yet. So I was praying before the Senate court to fix it after the hearing. which is
After?
The hearing of
When the civil court matter is fixed?
23rd May.
23rd May.
23rd May. Nothing will happen on 23rd.
Last date of the vacation.
Last day of the may not be a vacation instead of any event.
There also, I think so. No.
For 1 week. 1 week. We have 2 weeks there, 1 week. For 1 week.
The last date which was fixed for hearing, judge was not present on that day. That's why the hearing was not.
And even when the section 10 was filed based on the existing pleading. Now they want to change the pleading, that I will fight it out over there. It cannot affect the existing.
Why you are not paying the amount?
Well, this will result in contempt and other things, if whatever.
Yes.
My lord, my section 10 and my vacating of a team order is pending. Lordship, remember that I have filed section 10 because I have taken the point, but my suit is prior to filing this suit. Now, in the meantime, I filed one amendment application there. Copy was served. They have filed their opposition to my application. On the last date, copy the date?
On the 7th.
Last date when?
It is fixed on 23rd May.
It
Now
is
it
fixed
is
on
fixed on
23rd May
23rd
because the learned presiding officer was not there on the last date. That was my predicament. So if Lordship can just give me one more chance, Lordship. Because if it is amended.
Why payment is not being made?
So we are paying.
No, nothing. They
He's
paid
telling
only
that
1
it's
month.
not paid.
No areas, nothing paid. Only month of March is paid.
So monthly we are paying.
No, only month. One payment.
That is one payment was made.
No.
That is instruction is there. I'll take the instruction. If that is not, I'll ensure that that should be done because.
See, with regard to the adjournment, but.
No. I'm feeling very embarrassed, Lordship. No.
No areas paid.
Areas might not have paid, but monthly.
Whatever it may be.
Monthly she was paying because we.
Telling that nothing has been
Nothing.
paid.
Only the month of March is paid.
1 month payment was.
1 month payment.
I'll just take instruction. Or Lordship just fix a date. I'll come back with the proper instruction because.
Then can be to be
Because
mentioned
I'll
on
tell you very
Monday.
honestly, Poila Boshak, I went to a restaurant for the fish fry. I was told that she has paid for the appeal also. That is what I was told. So if that is there, so I did not check the document, but orally I trust my.
It has to be the areas payment is also there.
Areas not paid. I'm not seeing that, but monthly she was paying.
Oh, this is the statement, my lord. Yes.
Give me one more chance, Lordship. I'll come back with all the payments.
11th of March, one payment came of 50,000 rupees. That's the only one.
That is the only payment.
Yes, 11th of March.
So I'll ensure just give me one more chance because I was told there was some communication gap, but I've told no, I'm talking distrust coaching. Let me just cross check with me. I'm not. Mr. Mitros, I'm not. Our fix is in the first week of vacation, after vacation, Lordship.
No, what I'm saying, my lord, only for this instruction, if it is the next week, as a to be mentioned, so that he can take on this instruction with some payments to my client because he's not paid.
You will get the payment.
No.
You don't. You
Then
can
the
come
entire
with this.
vacation will go.
No.
He is not pressing his section 10.
Mr. Mitra, Mr. Kindly bear it for me. Regarding payment, suppose he is not paid in the month of April or May or June also. Matter will come. Lordship is yet to then pull my clients here. This is nothing. But I will try to see
he
that.
has not paid in August 2023.
Okay, I am doing one thing. Today we are on 6, 7. I am fixing day after tomorrow is to be mentioned. You take instruction.
He's on
when
this.
they
Yes.
will-
You get in 8 को बुझा नहीं है तो.
You take instruction over phone. when they fail.
Because areas lordship, what I can say that we had an impression that we'll go for section 10.
Okay.
But I said that at least for a month, every month you should not fail. That was that was a
they're not
discussion.
paying now for 4
No, that
months
is
has
very
been
unfortunate
passed.
because I have told them. So lordship, then can it can we come back next week, lordship, 13th?
Yes.
But I've got some medical reasons also in my house, so I'm 13th pay.
And from next week, this court will not be there.
Lordship, then let him wait for June.
No.
You will get the entire.
Your juniors are here.
He will get the entire money if he fails.
What this court will let not come on 8, take instruction, some payment be made with regard the court has passed an order, and subsequently I will fix the matter on June. Then meet.
Yes. By 8th, the payment of May will also fall due. It will be the 7th of every month.
Let us check.
Come on 8.
Yes.
Check with the sensation suffering for the plaintiff, sensation suffering for the defendant. Counsel for the defendant, plaintiff submitted in spite of the order passed by this court only, and defendant has paid only 1 month rent, that is for the month of March 2025, and thereafter the defendant has not paid any rent. Even arrears was also not paid. Counsel for the defendant prays for time to take instruction. In view of the above, let the matter appear on 8th for taking instruction.
Only one indulgence. This is for the instruction for the regarding payment. Regarding the fixing of this matter, lordship, can you fix it? Because then accordingly.
On that day we will.
Come on that day.
Can it be to be?
I will fix
if
it the month of June on.
Unless to be mentioned may not be called on because of.
ठीक है क्या बोला?
नहीं तुम्ही राखो.
As to be mentioned.
Minor, deeply.
As to be mentioned. Full stop. As regard hearing of the applications, let the matter appear.
Interim order is still today.
Let the matter appear on.
We are opening on 9th June.
9th.
So
on 12th of June 2025.
3 p.m. lordship.
No.
Hopefully that time I will be ready with the entire thing.
देखो कुछ है नहीं
The
होगा.
interim order is still today. Any day.
10th June कितना बजे? 10th June 3 p.m. 10th
3
June 3 p.m. Full. Counsel for the plaintiff submit the interim order granted earlier is going to be expired is due to expire today and paid for extension on the interim order. In view of the submission made by the counsel for the plaintiff, the interim order granted earlier is extended till 10th June 2025 or
Obliged.
further order whichever is submitted.
Obliged. পরশু আসছে করে দিয়েছি 10 জুন
I'm appearing on behalf of the petitioner. I mean, on behalf of the plaintiff.
For the respondent, defendant,
The application has been filed on behalf of the defendant for rejection of plaint. The direction was upon the plaintiff to file their affidavit in opposition. Carrying it in my hand, but it is not affirmed. I'm
For
only
the plaintiff?
beseeching, yes, I'm only beseeching
Affidavit
2 days' time,
my application.
within which I will be in a position to affirm it and serve a copy to my learned friend.
What about the main suit?
Regarding discovery and inspection of documents,
They have
a
completed.
part of it has completed. We completed our part, but this application has come in between.
Given the index of documents, we are required to take inspection of the documents.
We have given inspection.
Suffering for the plaintiff, sensation suffering for the defendant, counsel for the plaintiff, prays for extension of time to file affidavit in opposition in connection with GA Com 7 of 2025. Let affidavit in opposition be filed within 2 weeks.
I was only beseeching for 2 days. I leave it to your lordship.
Reply, if any, there to be filed within a week thereafter. Full stop. List the full stop. It is further submitted that the discovery and inspection of document has also not been completed. Accordingly, the parties are directed to complete the discovery and inspection of documents in the meantime. List the matter on.
May I beseech for a date and time convenient to your lordship? If it is possible in
it
June,
will go to July.
And only thing is, points will be a commercial, whether it's a commercial dispute or not. And Lady Moon's judgment was the judgment which Mr. Sarkar was relying on the last occasion, and your lordship's judgment. But it wouldn't take much time; even half an hour would be sufficient.
One judgment passed by my.
There is some time, in June. I request your lordship.
12th June at 3:45.
Friday, no, Thursday. It's a happy Thursday.
Thursday?
Yes. It's a happy Thursday. Deeply obliged.
Next. बर्जर पिंड में अपोजिट कोई नहीं है क्या?
This is my petition, my lord.
Hmm.
It's returnable today, my lord. An order was passed on 16th April 2025. Where, my lord,
Interim order.
interim order was passed, my lord.
Yes.
But here what had happened, my lord, my client had been supplying, my lord, paint in two forms. Where I say that, my lord, it's technical. To the respondent, my lord, respondent admits that there are dues, comes to my office, says that, look, there are dues, I have some problems. Then says that I'm going to sell off one of my property and give you the money. Then suddenly comes and says that, look, we are preparing a draft scheme. And in the draft scheme, which he shows me, he is only requiring or rather proposing to give me 10% of my dues.
Who was appearing? You.
I am appearing.
For the sole defendant.
Sole defendant, my lord.
Have you received the have you filed the affidavit? No.
Not filing affidavit, Lordship will not extend it. I'm opposing the extension on 2 counts. My lord. I'll just take 5 minutes of your Lordship time. I'm a little handicapped because none of it. Firstly, my lord, there is no compliance of 39(3)(ab). The plaint was not served. I'll show the letter. Only the injunction application has been served upon us. Kindly considers it. If not, my phone record also doesn't appear to be here. What was served was just the injunction. I'll be able to show that. If they show how it was served, no? The plaint is not a part of the injunction application. In the injunction application, there's a crave leave to refer to the plaint. And the plaint was not served. I don't think I'll need to cite a decision considering Mr. Ray is here, but kindly have a look at it. Enclosed copy of the injunction application along with its all annexures, notice of motion for your perusal, reference and record. So there is possibly no answer to this. This has to go. If he opposes this, which I'm sure he very well.
Opposing.
Then
Where is
kindly
the
just let them hand it over, my lord, formally how they've served. I'll take the point of 39(3)(ab). Only the injunction application. He's right. He's being correctly instructed. Please let them have. Please hand over the service so I can take the point of 39(3)(ab).
Okay.
No, they'll have to formally hand over the service. I don't know why they're not doing it. Hand over the service how you've effected it to.
Oh, yes, yes.
So I can take the point of 39(3)(ab).
Yes.
And a very unique case has been made out. Not on merits also, I'll address your lordship. Please have a look at this letter of 17th of April 2025. So this is mentioned. Next page for the, in terms of the order, I'm sorry, Miller.
Yes.
Further, in terms of the order passed by this honorable court, we are enclosing herewith a copy of the injunction application along with its annexures, notice of motion for your perusal. And enclosed as above. Injunction application, I'll just show that the plaint was not annexed, the plaint was only referred to. They've craved leave to refer to the plaint. Kindly have a look at paragraph page 10, paragraph 20. Immediately before paragraph 21 starts. Statement and contents of plaint are true and correct. Your plaint petitioner craves leave to refer to and rely upon a copy of the plaint.
Yes.
So plaint not served. On that, your lordship will allow me to cite one decision, but I don't think I need to for 39(3)(ab). So this is a, but I don't find it right now here. So Justice Pateria's judgment. But she will give me a minute.
Could it says otherwise?
Yes, next.
That's my first point. Second, my lord, a 12-day leave has been taken. Your lordship has seen, I don't know if this was shown because from how it was placed today, it appears that I owe them money and I go and tell them, look, I'm trying to sell off my unit. And then there is an immediate urgency. The pleaded case is from, I'll just indicate. The pleaded case is that from June, give me another, from February 2024 till June 24, this transaction happened. And his right in respect of this
this cause of action really accrued for recovery of the sum in June 2024. But the fact that I am going to sell my flat or my plant is irrelevant so far as he is concerned. This can be a ground for him to highlight something as a part of his cause of action. But his right to claim the money arises in June 2024. An impression is being given to your lordship that I have shown and I'm trying to sell this off. So firstly, this leave under 12A also was, I don't know how this was obtained, whether these pleadings were shown to your lordship. Secondly, Lord, the injunction has been granted on a property which is not naturally the subject matter of the suit. It's a money claim. I'm not on Rahul Shah. I'm on a slightly different point. There is no pleadings in this application in terms of Order 39 Rule 1B that I am trying to sell it off or dispose of my assets with the view to defraud my creditors. Not every plaintiff who comes to court is naturally a creditor. So at least by his stated case. So he's trying to defraud me is not the test of law. The mandatory pleading to get an injunction on a property which is not the subject matter of a suit or in a money claim is 39(1)(b). You have to plead that I'm trying to do it. That pleading is absent. There is no such pleading. I'll show us from his pleadings and I'll rely on one very oft-cited Justice Bhaskar Bachcha's division bench judgment. I'm sure everybody would have come and cited that. These 2 points. Thirdly, there is no question of defrauding my creditors as a class, because what they suppress from your lordship is this is a section 230 application, that there's a scheme. That scheme is filed in NCLT. The order is reserved. I'll just give your lordship the date on which, on 7th of March 2025, the NCLT reserves this order regarding my scheme which was sent before them. They may agree, may not agree. That's a different thing. But I have placed a scheme in terms of section 230 where I'm saying this is how I'm proposing to pay off my creditors.
But you given the scheme, but in the scheme, what is the percentage? Only
Correct.
14% something.
No, not 10, 20, but that's right. Your lordship is right. So I owe him, according to him, 10 rupees. My scheme says 10 rupees. It's actually going to be 20%, 10% in the total. So if, like, let's say my total outstanding to all my creditors is 100 and I am paying him off at 10. So apropos the scheme, it's 10%, but my scheme is 20% of what is outstanding is. So if that be the case, this is not a case where I'm trying to defraud my creditors. That case is also not made out. So if a case like this is not made out, whether the plaintiff can come and seek an injunction on a property in a money suit, which is not the subject matter of the suit. So 3 counts, I'm essentially today objecting to extension of this interim order. One is Order 39 Rule 3AB, mandatory compliance.
Yes.
That is clearly not done.
Yes.
And it is not, your lordship will find that there is a slight difference when plaint is annexed to the injunction application and that is served to me, and the plaint is not served separately. Then there is a departure saying, you know the contents of the plaint anyways, don't come and take these points. There's 1 or 2 Supreme Court decisions on that, but this is not that case. The plaint itself, in fact, when we were having this discussion, I wanted to have a look at the plaint. That's how the 39(3)AB point came, to see what his case is made out. The plaint is not there. So my first point of 39(3)AB,
yes,
this is a Khandani Properties decision, We could have found a better judgment, but this was short and crisp, so we thought. This is an application for vacating. Council disregards that.
yes.
Respondent informed order under cover. Application along with notice of motion was served on the respondents. The said service was insufficient as no copy of the plaint was served along with the application, which is mandatory under 39(3). Proceeding an affidavit. Counsel for plaintiff disregards all that. Having considered the submission of the parties, the order dated 4th September 2009 was an ex parte order, and by a letter of the same day, the plaintiff respondent communicated the gist of the order and forwarded a copy of the application along with the notice of motion. Order 39, Rule 3 of the Code of Civil Procedure contemplates service of not only the application, but a copy of the plaint and copies of documents on which the applicant relies. In the instant case, the application and copies of documents relied have been forwarded, but no copy of the plaint was forwarded. Service is not contemplated upon receipt of the order, not completed. The spirit of Order 39, Rule 3 under the proviso thereunder makes it clear that upon such order being passed,
the applicant is to forward the documents specified therein to the respondents. In the instant case, no such copy of the plaint was forwarded. The auditor so-and-so is liable to vacate it and is accordingly vacated. That's my first point. Second, my lord, if your lordship looks at the injunction application once, because I don't have a plaint, there's nothing else I can show. It's a short 12-page application. So let's just have a look at paragraph 25 onward. Your lordship will see this is on the point.
Yes.
And my lord, his ostensible cause of action to approach the court for something that had accrued in July 2024 is me telling him that I'm going to sell the property. Now, your lordship will just make a note of one date, my lord. By registered deed, this factory has been sold on 26th of March 2025. The agreement for sale was before. I'll give the date also.
This is 26 March sale date.
26 March 2025, this factory land has been sold. I'll rely on one decision, my lord, that where there is a registered deed. The whole purpose of registration under section 3 is to put the world at large on notice. So it's constructive notice. Anybody claiming any interest, not title, any interest apropos the immovable property is deemed to have knowledge. And where he doesn't have knowledge, it's willful abstentia. I ought to have found out, I have not found out, and they would have known. Well, this is a company, they come forward, they know there's an asset that has been sold, they had to do this only for the purpose of section 12A. This fact has been suppressed. That's my ground of suppression. Because if your lordship looks at paragraph 24, I'm slightly handicapped because I don't have the plaint. Otherwise, I could have shown whatever cause of action they pleaded. But paragraph 24, your lordship find that the respondent intending to sell the assets of the company at Faridabad. And this is then filed in on some day of April, which I can't understand.
24, the contention is there on 20th March 2025. Respondent intending to sell.
Correct.
Correct.
This is the meeting that I had with them. That meeting we have disclosed.
But your deed is on 26th of March.
26th of March. So 20th March, when I have the meeting with my creditors, and he's also there, what happens? I give him the compromise. The scheme, the scheme that is now before the NCLT is reserved for orders, that was given to him. Now, the scheme has all of this. The minutes records that. So on 20th March, he says, I got to know. He comes and file this on some day of April. I can't understand the date, but some day of April 2025. In the meantime, what he shows as his urgency, he doesn't even take steps with regard to finding out whether the property is still in existence. So please consider this, that a section 12A leave is taken for a cause of action in respect of something that has happened in July 2024. The because these goods lent, this was, I think goods were sold and delivered, and I had to pay him certain amount of money. This transaction completed in June 2024. So from June till April 2025, almost a year, they don't do anything. So for recovery of money, not me trying to sell my asset, is a security that they can have in aid of recovery. For recovery of money, they take no steps, which is what I'm trying to urge here. Well, section 12A leave is that his cause of action, there is an urgency, he needs an interim relief. So his cause of action is 1 year old, from June to 2025. April, it doesn't disclose this. Now, 25 onwards, your lordship will kindly have a look at. Your lordship will not find, at least how I have read it, there is pleading that I am trying to secrete away my assets or defraud the petitioner. 39(1)(b) if your lordship looks at, and I'll cite the decision, this is not enough. Because you are actually trying to meet a test in law which is of a higher degree, because in a simpliciter money claim, you are getting an injunction against me from dealing with a property in respect of which I have had no transaction with you. So something that is not the subject matter of the suit, because it's a suit for recovery of money, there is not enough to say I'm trying to defraud you. It is mandatory for you to plead that I'm doing this with the intent of defrauding my creditors. And you must, as a class, identify them. Kohinoor Steels takes it a little higher, my lord, because there Justice Bhattacharya's division bench holds that you've not given particulars or names of even one creditor. I'll cite that. And there's one passed by your lordship also on similar fact.
No. But if you're going on merit of the matter, then you have to, if you say that you will file affidavit, then I will hear on affidavit.
Well, the factory land which your lordship has injuncted,
No,
that
that's
factory
why-
land
that's
has
why-
been
that-
sold.
That's what I'm telling. If you want to argue the matter on merit at the time of vacating, because this court is having a girth of time. If today I will hear you, then I will hear you, then whatever the order is passed, then you will go to the appeal, then appeal say
Correct.
then
No,
there is
I
no
understand
affidavit.
that.
That
Not
is the
required.
problem.
This court
With
not
regard to the procedural aspect, okay, I will hear it. With regard to if you want to argue the matter on merit, if you say that you will not use the affidavit, then I will hear you, hear it now, and I will pass.
I will just give the particulars of my sale. Lordship will record it. My 39(3)(ab) point will stay because there's non-compliance of 39(3).
That's correct.
And I'll just give the particulars of the sale because technically that's the injunction he got post the sale. So whether the order gets vacated or not, it's
nothing.
Correct.
So you will not be affected because
Correct,
it has been done earlier.
Unless I don't want to, so kindly have a look at. Kindly have a look at it. Then your lordship will give me a short time to file an affidavit.
Correct,
I'll take all
bring
these
on
points.
record.
I'm refusing, I'm opposing any further prayer for an injunction today. This interim order really in view of what has now come before the court is pointless. Any further injunction, lordship will not grant. Give me a short time, I'll file an affidavit. No?
Further injunction means?
If Mr. Ray gets up and asks for something else.
Oh yes, I will. Well, since they're filing their affidavit, my lord, let them file their assets also, my lord, in view of Rahul Shah.
I'm opposing that. You know, that's a higher degree. Let him cite that.
Well, Rahul Shah clearly makes it a case that if it's a money suit, and obviously now, my lord, seeing the conduct of my learned friend's client, my lord,
there is no conduct.
Yes, it is a conduct.
So you file this in
It is
April.
definitely conduct, my lord. It's a definite conduct, my lord. Where, my lord,
it's a
they had
registered
said-
deed. You should have found this out.
I hope Mr. Banerjee has finished his arguments. Then I can argue. If he's done, then
continuously. This is a registered deed of sale, my lord.
Where is the schedule? Where is the schedule?
I'll just check. Page 3, na schedule last day ke hoy. It's in Hindi, I'm told.
Hindi, but in
Praman Patra or something. I'm not.
2824 Injunction system by where, but here the
Hindi,
plot
I am not.
Solicitor key.
I am not.
Here the plot number 23.
Well, I had gone to Lucknow once to do a matter. And there, no, Dilam I had gone to do a matter in Lucknow once, and there all these documents are in Hindi. I could not read, so I had to ask my advocate on record. So judge is telling me, कि Mr. Banerjee, आप यहाँ आ गए बहस करने. And I'm बहस. So he said, अरे बहस नहीं बहस. I thought in open court the judge was calling me. So that is my knowledge of Hindi. Then give the full deed.
Where is the schedule?
Schedule apparently is not there, at least in
property
what
is
is
not
here.
there.
But my instructions are that it's been sold, may not buy this registered deed.
Because in the paragraph, first you have given your address plot number 23, but there is no schedule here. Hindi also there is no schedule. This is the certificate.
All the particulars are there, but your lordship is right. I also don't see a schedule, but there is a recital. There's everything is the properties identified.
Even
the board resolution of the buyer is also there.
Even this paragraphs also, there is no mentioning about that. That is another khasra. Khasra of Muttil number 39.
39.
That is different one. Take instruction. Yes, what about the 39 one A and B?
Well, may I come back tomorrow?
Interim order till today.
What is today?
I will keep tomorrow, no problem, but interim order is till today only.
एमनी बिक्री होएगा जो interim order है कि
The point is very simple, my lord. Today, my lord, I can argue, but if it is really been sold out, then it's
Correct.
I have no use. But that's
So
why I just
what
wanted.
I propose, see, if you sold out, nothing. I am extending this. This order maybe let it be first week of June and reopening. You come with the affidavit disclosing that, and I will hear the matter on merit. If it is sold out, then automatically.
At least just record my submission that
yes, record
yes,
this.
yes.
I will record.
Yes, yes, my lord. But I'll take your lordship's kind leave.
So appearing for the plaintiff, so appearing for the defendant. Full stop. Counsel for the defendant. Counsel for the plaintiff has filed affidavit of service. Let the same be kept with the record. Counsel for the defendant has raised objection on the point that the plaintiff, though has served the copy of the application along with the document, but the plaintiff has not served the copy of the plaint, and as such the plaintiff has not complied with the order 39 rule 2 within bracket A and B. No, 3A and B. Order 39 rule 3A and B. Small a, small b, of the CPC. The counsel for the defendant further raised an objection that the property in which this court has granted interim order, the defendant has already executed a deed prior to the order passed by this court and registered a deed on 26th of March 2025, that is prior to the interim order passed by this court. Full stop. The defendant has handed over the copy of the deed dated 26th of March 2025, but this court did not find the schedule of the property in the said deed. Accordingly, full stop. The defendant is directed to file affidavit in opposition within a period of 2 weeks after supplying the 2 weeks. 2 weeks. After supplying the copy to the learned counsel for the plaintiff. Plaintiff has liberty to file reply within 2 weeks thereafter. Full stop. Let the matter appear on 12th June, 11th June 2025. Under the same heading. The interim order granted earlier is extended till 11th June 2025.
11th is right. Well, the next matter I was requesting.
May I just hand over a copy of the plain to my learned friend?
Will take. No, you will not take. I will distribute. Okay.
No problem.
Yes.
My lord, the next matter, lordship, my lord, I was only requesting your lordship to
Which
call.
matter?
My lord, 16.
My
lord, this was, my lord, a matter where lordship had permitted us to, my lord, lodge the writ of summons for reissuance on 2 of the defendants, defendant number 2 and defendant number 5. One was Asansol Municipal Corporation and one was an ex-employee. We have complied with your lordship's order, but my lord, we have requested the registrar as well as the office of the sheriff, my lord, to indicate whether it was done or not. My lord, the report may be called for, then my lord, it would be easy.
Obtain report.
My lord, we have been writing letters, but we have not, my lord, received a report. This is the last letter, my lord. It was only to ensure, my lord, that defendant number 2 and defendant number 5 has been, my lord, served again.
Record a note. Who is for the defendant? Why you are going back? Appear, you will get.
I'm not there.
Sentence appearing for the plaintiff, then appears on behalf of the defendant. Counsel for the plaintiff submit that in terms of the order passed by this court dated 25th March.
Yes, my lord.
25th March, the plaintiff has taken appropriate steps for lodging of fresh writ of summons upon the defendant number 1 and 2.
My lord, 2 and 5. That was your lordship's order.
2 and 5. 2 and 5. Full stop. Counsel for the plaintiff submitted. The plaintiff has made several requests to the concerned authority, to the department, to ascertain whether the writ of summons is served upon the defendant number 2 and 5 and whether their defendant number 2 and 5 entered appearance or not, but no reply, no report has been issued by the defendant and by the plaintiff. In view of the above, the department is directed to submit report by the next date fixed whether the writ of summons was issued upon the defendant number 2 and 5 and whether they have entered appearance or filed written statement.
Very grateful, my lord.
Let the matter appear on 17th June 2020.
My lord, the next item, your lordship, item number 17, my lord.
Yes.
My lord, in this matter, your lordship had passed an order on 23rd April, your lordship. May I hand over a copy of the order?
Yes.
My lord, we are taking appropriate steps. The application is being filed today in the department, my lord. My lord, the application, my lord, there is an application being filed. Your lordship had directed us to take steps, appropriate steps. My lord, we are filing an application for bringing on, serving the state of Madhya Pradesh and the directors thereof. And
in this matter, AG will be appearing in this matter.
the AG will be appearing, your
I'm
lordship.
for time.
AG will appear on behalf of whom? Judgment debtor?
Yes, the judgment letter, your lordship, the state of Madhya Pradesh is there, my lord.
Okay.
So we are taking out an application, your lordship. Will kindly fix it on the 15th of May, my lord.
15th of May?
Yes, your lordship. Because by that time, the master summons will be taken.
Circuit.
You can argue. Sensations appearing for the plaintiff and degree holder. Sensations appearing for the judgment debtor. As per the prayer made by the counsel for the degree holder, case is adjourned. Let the matter appear on 11th June.
Grateful.
But items 18, 19, 20 execution matter for filing of affidavit of assets. It was supposed to be filed by
There is no direction for filing.
yes.
Who is appearing?
21st March. I am for the
Who is for the
holder.
judgment
No, they
debtor?
were here right now.
Nobody is
Yes,
left.
yes, here they are.
Yes.
Your Lordship, we have
Two
filed
directions.
the affidavit of assets,
File
but
it.
it's with senior counsel. He left just now.
You take it from him and file it. How can you give it to your counsel?
Come tomorrow.
Yes, Your Lordship.
Come tomorrow. Not today. Yes, the other fixed matter.
My lord,
I have some other meetings, so I have
very
to.
well. Would it be
so
Lordship's pleasure to indicate another date, my lord, subject to Lordship's convenience, my lord?
19 June at 3 p.m. Item number 12, huh?
Item number 17.
12, 12.
12. I'm so sorry.
Sensation suffering for the plaintiff, though the matter is fixed today, especially fixed today at 3:45 p.m. for hearing, but due to paucity of time, the hearing could not, and the matter could not be taken up for hearing at all. Accordingly, cases adjourned. Let the matter appear on 19th June at 3:45 p.m.
I'm so grateful, my lord.
Hey, कौन सा file का देख?